But my humble is that only 30,000 while lying in my file, for which I have filed.
Please wait. We are in the process
No,
of
Lord,
hearing.
what about statement, my lord? It may come in the
Please
office.
wait. Please wait. Please wait. We will make arrangements. Yes. Yes. Mr. Chidambaram, please start.
May it please your lordships. I had congratulated what I intend to do with your lordship's permission is go according to the sequence, make my submissions and each head of submission,
Yes.
and I will rest my case. Mainly, my lord, I will be dealing with the law. Some facts, of course, will have to be stated. My lord, after the last hearing, on each of these 8 submissions, I had filed one affidavit giving some data and explaining these 8 submissions. That affidavit was filed on the 5th of November 2022. If your lordships can
You the affidavit of fifth now.
find that affidavit of 5th of November.
Yes.
And they filed a counter affidavit after that. 5th November.
It's in 916, writ petition 916, Adilal, in that.
Just give us that affidavit. Where is it?
Well, it is a paper book in the name of Ms. Chaiswal in 916 of 2016.
Filed 711, additional affidavit 7/11/20.
We don't have here. Just pick up that.
It's not there. Not that one. These 3 just haven't allowed you to start searching because otherwise you go through this process again. That's how they get that. You don't have, this is section. It's a thin volume of 25 pages. Yeah, that should, no, this is rejoinder, but you keep this out. We'll need this also.
Is it pages number 1 to 170?
No, my lord, it's
No,
25
a
pages.
short affidavit,
1 to 20.
25 pages.
I think we got it first.
Yes, yes. Can't see what it is. Yeah, this is heads of, we've handed this over, so you don't need, so you just handed over copies of this.
Sorry, my lord, too many volumes and too many affidavits.
Such matters, I think there should be one convenience compilation containing all the documents because it becomes difficult to go
Lord,
from
I'm
one
not
volume to other
referring to
volume.
too many documents. I just want to refer to this affidavit. Two copies here.
No, they found. I'm saying you now mark everything else we filed also. You can mark it in this one.
Okay.
I don't think they found for all the.
Because we do also for the finance. I have two extra copies while I'm reading. Yeah, I have two extra.
We have two extra copies, my lord. My lady justice, Margaret from Maynard. Please give that extra copy.
They're given to us.
But why I'm referring to this affidavit is for the sake of discipline and economy of time. As I deal with each head, I just want to read portions of this affidavit, which contains some facts, and then make the submissions. So this is the approach that I wish to adopt, my lord, with your lordships. Now kindly, my lord, have the Reserve Bank of India Act.
Sorry to tell you, I think you have to maintain silence in the court.
Conversations would be outside the court.
Yes.
So solicitor, you can request the person behind
Yes.
you.
Lord, will ensure that
Silence.
there is no, will ensure, my lord, that there is no
Not-
murmuring internally.
Not discussions.
Yes, your lordship said it. This is not the place.
Sometimes prompting is okay, but
Yes.
So the Reserve Bank of India Act, kindly just see the preamble. There's one line in the preamble. Whereas it is
Sorry, 1 second. Mr. Chief.
RBI Act,
Yes, which section? Which section?
preamble,
remember.
preamble. This is a 1934 Act.
Yes, we have.
Whereas it is expedient to constitute a Reserve Bank of India to regulate the issue of bank notes and the keeping of reserves with a view to secure monetary stability, and generally to operate the currency and credit system of the country. You know, the right to regulate the issue of bank notes is entirely with the Reserve Bank of India, and generally to operate the currency and credit system of the country to its advantage. Now, Millet, kindly have section 3, establishment and incorporation of Reserve Bank. I'm not reading the sections. And kindly come to section 8, which is important. The central board shall consist of the following directors, namely a governor and not more than 4 deputy governors to be appointed by the central government. 4 directors to be nominated by the central government, 1 from each of the 4 local boards as constituted by section 9. C, 10 directors to be nominated by the central government, and D, 2 government officials to be nominated by the central government. Well, usually the 2 officials are the Secretary Economic Affairs and Secretary Banking, but that's not material for our purposes today. But 8(1)(c) is the only input into the board other than officials. 8(1)(a) is officials. 8(1)(b) is from the 4 local boards of the RBI. E is 2 government officials. C is the only input of non-official input, if I may call it. Usually, my lord, people representing various walks of life economic activity are appointed. Industrialists, agriculturists, economists, they are usually appointed under 8(1)(c). On the date of demonetization, and this is subject to correction, 7 of these 10 posts were vacant. 7 had not been nominated. 7 were vacant. Only 3 directors were there under 8(1)(c). But that can be corrected by the learned Solicitor General. Now, then kindly come to 13. Meetings of the Central Board. Meetings of the Central Board shall be convened by the Governor at least 6 times in each year and at least once in each quarter. Rest is not relevant. Then kindly come to section 26, which is the crucial section. Or 24 to start with. 24. 22 minutes, that whole chapter, but 22. I won't read it. Right to issue banknotes. Your Lordship saw the preamble. The bank shall have the sole right to issue banknotes in India, and may, for a period which shall be fixed by the central government on the recommendation of the Central Board, issue currency notes of the Government of India, supplied to it by the central government, and the provisions of this Act applicable to bank notes shall, unless a contrary intention appears, apply to all currency notes of the Government of India issued by the central government or the bank in like manner as if such currency notes were bank notes, and references to this Act. My Lord, this is the second part is rarely, to my knowledge, it's never been done. Bank issues the currency, bank notes. Then the issue of bank notes should be conducted by the bank in an issue department, which shall be separated and kept wholly distinct from the banking department. And the assets of the issue department shall not be subject to any liability other than the liabilities of the issue department, as hereinafter defined in section 34. The issue department shall not issue bank notes to the banking department or any other person except in exchange for other bank notes or for such coin, bullion, or securities as are permitted by this Act to form part of the reserve. My Lord, what happens, how is it reflected in the balance sheet of the RBI when currency notes are issued? I'll come to a little later. It's a liability of the Reserve Bank of India once they issue them. That is why the legend is there, I promise to pay. So it's a liability of the Reserve Bank undertakes if somebody presents that. Now, denomination. Subject to the provisions of subsection 2, banknotes shall be of the denominational values 2 rupees, 5 rupees, 10, 20, 50, 100, 500, 1,000, 5,000, and 10,000, or such other denominational value not exceeding 10,000 rupees, as the central government may, on the recommendation of the central government, the central board, specify in this book. My Lord, the highest note can only be 10,000 rupees under the Act.
Has it been printed anytime, 10,000?
Yes, 10,000 was in circulation in 1946 and up to 1978. That's why the demonetization of 46 demonetized the 10,000 rupee note. 5,000 was also available. But hardly in the hands
That
of
earlier judgment is with regard to 10,000.
10,000 and 5,000. The highest denomination is 10,000. Then, the central government may, on the recommendation of the central board, direct the non-issue or the discontinuance of issue of banknotes of such denominational values as it may specify in this regard. For example, my Lord, 1,000 rupee notes have been discontinued after demonetization. The point I'm making in section 24 22 to 24 is, the bank shall have the sole right to issue bank notes, and any power conferred on the government is only on the recommendation of the central board. So 26 is not to be read in the out of context. 22, 23, 24, 26 are all part of a scheme where the sole right is with the Reserve Bank, and any power conferred on the central government can be exercised to specify this or that only on the recommendation of the central government. So the point I'm submitting is obvious, that the central government cannot on its own initiate any proposal relating to currency notes. It can only be on the central board's recommendation. Again, Miller, kindly see 25. The design from the material of bank notes shall be such as may be approved with the central government after consideration of the recommendations made by the central board. So 22, 23, 24, 25 are part of a scheme, and then 26 comes. Subject to the provisions of subsection 2.
Did you read this subsection 2 of section 24?
24. Central government may, I read it, Malad, on the recommendation of the central board, direct the non-issue. I said 1,000 rupee notes have been discontinued. On the recommendation of the central board, the central government may direct the non-issue or the discontinuance of issue of bank notes of such a denomination. The two examples straight away, 1,000 rupee notes have been discontinued, 2,000 are no longer issued. What was issued immediately after demonetization, now no 2,000 rupee notes are issued.
No, whether demonetization is equivalent to non-issue, discontinue?
No. Demonetization is in 26. Declare that note no longer legal tender. The non-issue of a note means that the issued notes will still be legal tender.
Yes, this is what I.
Discontinuance means issued notes will still be legal tender.
Yes.
You will not print and issue more notes
In future,
of that denomination.
that is for future.
Future. My lady's right. Future. But again, Miller, 25 can only be on the recommendation of the central board. Now, please see 22, 23, 24, 25. In that context, please look at 26. Subject to the provisions of subsection 2, every bank note shall be legal tender at any place in India in payment or on account for the amount expressed therein, and shall be guaranteed by the central government. 2. On recommendation of the central board, the central government may, by notification in the Gazette of India, declare that with effect from such date as may be specified in the notification, any series of bank notes of any denomination shall cease to be legal tender, save at such office or agency of the bank, and to such extent as may be specified in the notification. And 26A, which was introduced in 1956, notwithstanding anything contained in section 26, no bank note of the denominational value of 500 rupees, 1,000 rupees, or 10,000 rupees issued before the 13th day of January 1946 shall be legal tender in payment on an account for the amount expressed therein. Well, that is following the 1946 denomination. Shall be legal tender in payment on an account of amount expressed therein. Then reissue of notes recovery of notes lost, stolen, mutilated, or imperfect, issue of special banknotes. We're not concerned with all that. Well, the first submission is, Lordship will have that affidavit. What is the scope of 26.2? That is the submission which I made on the last occasion, and that is the submission which I will elaborate today. Just kindly have this affidavit, my lord, that will save a lot of time. Kindly come to paragraph 4.
Yes.
Kindly come to paragraph 4. Petitioner craves leave to state briefly the purpose of currency and the concept of currency in circulation. According to all economists, currency has three purposes: store of value, unit of account, medium of exchange. Each one of the three purposes is necessarily and intimately connected with the daily life of every citizen. In particular, since currency is a store of value and a medium of exchange, it is widely preferred to any other system. The currency system is convenient, easy to access, not dependent upon any technology, and gives the holder a large degree of autonomy and confidence that no other system can give. It is completely wrong to say that advanced countries have less currency or have become cashless. Data will show that even in advanced countries in the year 2016, currency represented an overwhelming, or at least a very large proportion, the different mediums of payment. Then we have given Miller the table shows Australia, Austria, Canada, France, Germany. The bulk of the transactions were in 2016 still in cash. It is also a well-established truth based on empirical data that in times of distress, people fall back on currency and actually hold more currency. For instance, at the time of demonetization, the currency in circulation was rupees 17.97 lakh crore. Your Lordship may kindly underline that number. Today, according to the RBI's press release, it is 32.18 lakh. So actually the currency in circulation has increased. There's more cash with the people. And that, my lord, is, I may say with humility, economic logic. As the GDP grows, more people have more income. There will be a requirement of more currency, which is why the right to issue currency is given to one independent authority. It is that independent authority alone which can decide what is the cash in circulation that the people need in order to carry out their daily activities. Requirements of personal expenses, requirements of household savings, requirements of business, requirements of commerce, all that must be assessed, and the RBI has got a huge machinery to assess that and research that, and it will decide. This power
Maybe population growth also, perhaps.
obviously, population growth and the size of the economy. The GDP grows, there will be more transactions and more money. This power is not given to the executive government, but the executive government can, I'm not saying this government or that government, an executive government can starve people of cash and cripple their daily activity by not putting enough cash in circulation. Which is why, my lord, back in 1934 and in all countries, the right to issue currency, the sole right is only with the Reserve Bank of India, and they will decide how much currency people require. Simply by the fiat of demonetization, you're withdrawing 86.4% of currency. That doesn't mean the people don't require that currency. They require it. And today, look at after 6 years, 17.97 lakh crore has ballooned to 32.18 lakh crore. And if I may with humility, make a prediction, it will continue to grow. It will continue to grow. It should, it ought to grow.
Mr. Chidambaram, one question here.
Yes.
This 17.97 lakh crore is after demonetization
No,
or before?
just before
Demonetization.
just before demonetization.
Hmm.
And I'll give the three numbers. 17.97 lakh crore was the currency in circulation. 500 and 100 rupee note accounted for 15.44 lakh crore. That is coming later, 86.4%. 86.4% was in two denominations. And you withdrew that, leaving as legal tender only about 2 lakh crore. And obviously, people were put to tremendous hardship and distress because 2 lakh crore is not enough to sustain the life of, say, 125 crore people. We have to buy, sell, exchange, pay loans, take loans, whatever. Anyway, that is a separate question. The point is, the currency in circulation, the value, the amount of currency in circulation must be determined only by the Reserve Bank of India. That is why anything to do with currency must emanate from the Reserve Bank of India. Yes, there is a power to demonetize, but that power must be exercised only when the Reserve Bank of India makes that recommendation. The Lordship may keep that submission back in the mind because that is the foundation of my submissions. Now, madam, then to the best of, hence, despite demonetization, currency in circulation has actually increased, reflecting the people's faith in currency and the assurance and confidence that is gained by holding currency. To the best of the petitioner's knowledge and belief, demonetization is resorted to in rare and exceptional circumstances. Historically, governments have resorted to demonetization in the following two circumstances: to weed out denominations of currency that are in disuse or are practically unusable. Pausing here, 10,000 rupees note, my lord, in 1946 or 1978, and even today, is practically unusable. If I try to exchange a 10,000 rupee note in the market, people will look upon me with suspicion. Is this a fake note or is it a genuine note? Therefore, 10,000 rupees hardly, I'm not sure if any of your lordships have seen a 10,000 rupee note. In fact, my lord, I remember when I started practice, 1968, even a 1,000 rupee note was a rare possession of very rich people or people in the trade. If you had 100 rupee notes in your pocket, you were considered a well-to-do person in 1968. By 1976, I agree, 500 rupee notes had come into circulation. Even today, my lord, the highest note in circulation and being issued is only 500 rupee note. 1,000 has been completely discontinued and 2,000 is no longer issued. Discontinuance and non-issue. So the highest currency in circulation is 500. So practically unusable denominations will be demonetized. They are meaningless. Then get rid of currency which has become worthless in value because of hyperinflation. Turkey today has an inflation running into several, 3 digits. The currency becomes worthless. Argentina, Zimbabwe, Turkey. The currency becomes completely worthless. So what's the point of keeping that currency? It is demonetized. Now, then, for example, in 1946, the government of India demonetized currency of the denominations of 500, 1,000 and 10,000 that had been issued earlier by the colonial government. The reasons were that these denominations were in 1946, in fact, high denomination notes and were used by a very small number of people. Well, whether a denomination is a high denomination, this does not depend upon the number. It also depends upon its the frequency of exchange. What is high denomination at one point of time may become common denomination as 500 became. I'll read on them. In fact, these high denomination notes in 1946 could not be easily exchanged in a village shanty or market or small towns. Besides, they had been issued by a colonial government, and on the eve of independence, the interim government was keen to introduce its own notes. Again in 1978, currency notes in the denominations of 1,000, 5,000, and 10,000 were demonetized. In 1978, these denominations were in fact high denomination notes and were used only by a very small section of the people. It was also very difficult to exchange these notes in village, small towns, and markets. Even in cities, these notes could be only exchanged in a bank. Besides, these high denomination notes that were demonetized in 1946 and 1978 represented only a very small proportion of the currency. Now, this paragraph may be marked. The proportion in 1946 was around 11.5%. Because in 46, most people had very little currency. And in many parts of India, currency was not the medium of exchange, barter was the medium of exchange in 1946. Therefore, very few people had currency in their hands. And in 1978, the demonetized denominations were only 0.6%, which is why there was no hue and cry in 1978. There was no hue and cry when you demonetized 1,000, 5,000, and 10,000. There was no hue and cry at all because only 0.6% was withdrawn. Although the demonetizations of 1946 and 1978 purport to demonetize high denomination notes, such demonetization did not affect the overwhelming majority of the population, nor did it disrupt daily life, nor did it have terrible consequences on the economy. The vast majority of currency notes in circulation in 1946 and 1978 were in the denomination of 1, 2, 5, 10, and 100. With this background, the petitioner begs to submit as follows. Now, this is my first submission, first head of submission, this background. On its true interpretation, Section 26(2) of the RBI Act does not permit declaring as no longer legal tender all series of notes of a specified denomination. The sections must be read down to mean that any series means a specified series of notes of a denomination. The series is denoted by an alphabet, a number, a photograph, and the year of issue. Any series does not mean all series of notes of that denomination. Section 26(2) allows the government to declare that any series of banknotes of any denomination shall cease to be legal tender. The language of Section 26(2) may be contrasted with the language of Section 3. I'll show the ordinance and the act. Let me complete it reading this minute. Section 3 read with Section 2C of the Ordinance of 1946, as well as Section 3 read with Section 2D of the Act of 78. In the two earlier legislations, the reference was only to high denomination banknotes. These notes were not qualified by the words any series. It is submitted that currency notes are issued in a series and different series of notes are issued from time to time. For example, the notes issued currently are known as the Mahatma Gandhi New Series. Some years ago, the notes that were issued were known as Mahatma Gandhi Series. It is submitted that the addition of the words any series before the words of banknotes of any denomination limits the power of the government to declare only a specified series of notes as no longer legal tender. It is submitted that any series means any specified series and not all series. It is submitted that Parliament had the same power in 1946 as well in 1978 as it had in 2016 under Section 26(2). The Act is of 1934 Act. Nevertheless, Parliament concluded that the demonetization that was intended could not be done under 26(2) of the RBI Act and required separate legislation. In 1946 and 1978, Parliament intended to declare all series of the specified denomination of notes as no longer legal tender. Since this power was found to be not available in 26(2), Parliament passed a separate law on each of the two occasions. It is submitted that in 2016-2, if the government intended to declare all series of notes of the denomination of 500 and 1,000 as no longer legal tender, it could not have done so by making a notification under 26-2 and could have done so only by passing a separate legislation. As a result of demonetization done on 8/11, even currency notes issued on the previous day in the denomination of 500 and 1,000 have become illegal tender. It is absurd to say that 26-2 confers the power upon the executive government to issue a currency note of 500 or 1,000 on 7th of November and demonetize the same on the 8th of November. It is submitted that such a power cannot be located in 26-2 and it is intended to demonetize all series of notes whenever issued of a particular denomination as no longer legal tender. That could be done only by Parliament debating the matter and passing a separate legislation. So this is the main submission. Now, please see, my lord, the contrast the language of 26-2 of the contrast the language of 26-2 with the language in the ordinance and in the 1978 Act. Well, the ordinance was available to your lordships last time. I don't know. So, filed in someone.
Union is filed.
Union is filed it.
2006 ordinance.
So,
Yes, we have.
you have lordships have.
Yes, we have.
Now kindly see the 1946 ordinance. They've got it. Whereas an emergency has arisen, which makes it necessary to provide for the demonetization of certain high denomination banknotes. Now therefore, the exercise of the powers conferred by 72 of the Government of India Act, that is the Constitution then, as set out in the 9th schedule, the Governor General is pleased to make. It's not under the RBI Act. RBI Act was available, but they resorted to plenary legislation under the Government of India Act. Now kindly see,
Section
C
72,
defines high denomination banknote.
Section 72 of the Government of India Act must have been the ordinance making power.
Yes, but they did not resort to the RBI Act, they resorted to plenary legislation. And Government of India Act should have a schedule, my lord, what is the powers of Parliament, like our 9th schedule, 7th schedule. So, now kindly see the definition in 2C. High denomination banknote means a banknote of the denominational value of 500, 1,000 and 10,000 rupees. Now read 2C with section 3. On the expiry of the 12th day of January 1946, all high denomination banknotes shall, notwithstanding anything contained in section 26 of the Reserve Bank of India Act, cease to be legal tender in payment or on account at any place in British India. The three things flow. One, this plenary legislation was notwithstanding anything in section 26. They said section 26 does not limit our power. We are passing a plenary law. Number two, it is not any series of high denomination banknote. It is all high denomination banknotes. And number three, my lord, this was done by separate legislation.
That may not make much difference because high denominate notes are defined. High denominate notes means
Yes,
of the value of 500 or 1,000. 1,000.
precisely my point.
That's right.
The 500 and 1,000
Yes.
would have been issued in several series.
Yes.
There may have been a 1935 series, a 1940 series. Now they are demonetizing or declaring as no longer legal tender all notes of that denomination. Whether Section 26 conferred that power is the question. Parliament then, or the government then, thought, and according to me rightly, Section 26 does not give that power to declare all series of the high denomination as no longer legal tender. Therefore, in order to declare all series as no longer legal tender, you had to pass plenary legislation. The contrast will become obvious, my lord, when Lordship sees the present notification. The point I'm making is the words any series of high denominational banknote is not in this. The words any series is not in this ordinance. It's all high denomination notes of that particular denomination. I hope I'm making
Yes,
sense.
yes.
I will show. I'll show what a series is, my lord. The contrast.
Your submission is that powers under section 26(2) is restricted only for a particular series.
That is my submission.
And the notes of all series of a particular denomination cannot be
Yes.
demonetized under section 26(2).
That is my submission. That is my submission. Let's take one denomination, my lord, for the sake of easy, 500 rupee note. Now, 500 rupee note would have been issued in several series. 26(2) says any series of banknotes of any denomination. Why did it add the word any series in 26(2)? Whereas when the law is made here, the word any series is not there. Any series is not there. And then section 3, all high denomination notes of 500 are demonetized. Look, there must be a meaning to why any series is in 26(2), and therefore Parliament or the government then in 1946 concluded, if I want to demonetize all the series of 500, series 1, series 2, series 3, I cannot resort to 26(2). I have to make a special legislation. They made this legislation, and it specifically says all high denomination banknotes shall cease to be legal tender.
What you are suggesting is any series does not mean all series.
That is my suggestion. Specified series.
Are
1978.
you suggesting that
Yeah.
if a separate ordinance or a law had been made in this case, it would have been valid?
If a law had been made in Parliament, this may have been valid. Because Parliament would have debated it thoroughly and taken into account all the consequences of withdrawing 86.4%. Parliament would have demanded information. What is the proportion of these notes? How much will be withdrawn? How will it affect people? I'm assuming a debate has taken place in Parliament. But if you do it by notification, then we'll come to that, well, what is the material they have? That is a separate argument. Now kindly see the 1978 Act.
Just 1 second.
Please.
What was the lifespan of an ordinance under the Government of India Act? Any idea? Is it 6 months like the present day?
I'll look into that, Malad. I think,
Huh? In those days, what was the lifespan? Any idea?
I'll examine that and let you know. Under the 19.
No, the next question is, what happened to this ordinance after the expiry of the period? Any idea?
Well, I'll look into the 1935 Act and let your lordships know.
Was it made an act or what happened to this ordinance?
Whether an ordinance then required, for example, there's a criminal law amendment ordinance.
Yes.
It's still an ordinance. I look into the 1935.
No, that is if it has no particular lifespan.
I look into the 1935 Act. I don't have an answer and I'm sorry.
All right.
I look into that. Now the 1978 Act,
Yeah.
1978 Act buttresses my argument. Why did you make a separate law in 1978? Now please see, keep the 1946 ordinance and now look at the 1978 Act, the definition. Does your lordship have the 1978 Act?
Yes, sir.
Now please see. Definitions.
Mr. Chidambara, one more, sorry, I'm asking you too many questions. Now, what is the legal position? Let us assume the act governs a particular situation. 26(2), for example, here. Can you exercise plenary power for that very purpose again under what is the law on the point?
My reading of 26(2).
No, assuming in a given case. In a given case, what is the legal position?
My reading of the RBI Act, especially 26(2), is it does not give the power to declare as no longer legal tender all the series of a particular denomination. If you wanted that power, you must pass a separate law. It only gives the RBI and the government the
A
power
particular
to
series.
declare
A particular series.
any particular series. If you want to declare all the series of a denomination, that requires a separate law. The 1978 Act, I asked myself, why in the face of 26(2), forget the 1946 pre-independence ordinance of the then government. In independent India, Parliament, under the Constitution, in 1978, the government decided some notes have to be demonetized. If 26(2) contained that power, why did they pass a separate law? Now, please look at this law of 1978. Again, it says, notwithstanding anything in 26, please see this act. Now, kindly see the definitions. 2D. In 46, it was 2C. Now it's 2D. High denomination banknote means a banknote of the denominational value of 1,000 rupees, 5,000 rupees, or 10,000 rupees issued by the RBI immediately before the commencement of this act. You know, this was first as an ordinance and then replaced by an act. Now, please look at 2C also. After reading high denomination banknote, distinctive number in relation to a high denomination banknote means the number including the alphabetical and numerical prefixes appearing on the face of the note. Now look at section 3. On the expiry of the 16th day of January, all high denomination notes shall, notwithstanding anything contained in section 26 of the RBI Act, cease to be legal tender. If this power is already there in 26(2), then why did you have to make this law? Therefore, my lord, the language of 26(2), which clearly says any series of banknotes must be contrasted with section 3 of the 1978 Act, all high denomination banknotes. It is not any series of high denomination banknotes. And why did they have to say, notwithstanding anything contained in section 26? If 26 has the power, why did you have require this law? And why did you have to be overriding 26? Therefore, my lord, the submission is 26(2) gave a limited power. Limited power to declare no longer legal tender any series of 500 rupee notes, any series of 1000 rupee notes. If you wanted to declare no longer legal tender all the series of 500 rupee note, all the series of 1000 rupee note, you required special legislation, which is why special legislation was made in 1946 and 1978 to declare all the series of 500, 1000, 10,000 as no longer legal. That is a submission.
Yes.
Now, in that light, kindly take a second look at 26A, which was introduced in 1956. Notwithstanding anything contained in section 26, no banknote of the denominational value of 500 rupees, 1000 rupees, or 10,000 rupees issued before the 13th day of January 1946 shall be legal tender in payment on account of amount expressed therein. This, my lord, follows the 46 ordinance. 46 ordinance was made on the 12th of January 1946. 12th of January, all the series of 500,000, 5,000 were declared legal tender. And 26A was made way back in 1956. There was some doubt. They said, notwithstanding anything contained in section 26, no banknote of the denominational value of so-and-so issued before the 13th day of January shall be legal tender. It's like putting a double lock on the door. The ordinance of 46 was one lock and 26A was another lock. Because 26 did not have that power. If 26 had that power, then all this is unnecessary. The submission, first submission is, and I conclude on that, any series must mean something. This is not surplusage. This is not surplus words. Any series of banknotes must be read as any specified series of banknotes of any denomination. Look at the absurdity of the example that I put in the affidavit. Later on, it will come. 300 crore distinct notes can be printed by all the printing presses of India. 300 crore distinct pieces, 5 rupee, 10 rupee, whatever. That is the capacity of all our printing presses. And we print practically round the clock, around the year. Now, you print and issue, notes are printed and issued depending upon the demand for notes. Soil notes come back, well, after a particular number of years, soil notes are not reissued by banks. They are impounded and destroyed. And then new notes are reissued. Now, you print and issue a series on the 7th of November. Can you demonetize it on the 8th of November? Well, it's so absurd and unreasonable to say any series means all series. I issued one last month. I printed notes of a new series, let's say Mahatma Gandhi new series. I printed it last month, 500 and 1,000. And today I will demonetize it. I mean, that is arbitrary exercise of power. That is why any series means RBI must apply its mind. Which series must be demonetized? When was it issued? Was it issued many years earlier? What is the total value of currency in that series in circulation? All that is available to the RBI. Can we declare it no longer legal tender? So you have to apply your mind to which series you want to be demonetized and then make a recommendation to the government of India. And the government of India may or may not accept a recommendation. If it accepts a recommendation, it may say, all right, go ahead and demonetize it. It can't be, my lord, that notes are issued 1 week earlier and demonetized on the 8th of November. My lord, that power, whatever happened in 2016 has happened. But that power, your lordship should deny to the government if the government asserts it has that power. Your lordships must say for the future, you cannot do that. It will throw the country into complete chaos. Any government can come and say, I am demonetizing news. It issued last month. Suppose a new series is issued now. Mahatma Gandhi, second new series. Then I demonetize it the next day. Please don't give that power to any executive government. Therefore, please read any series to mean any specified series of banknotes where the RBI board must apply its mind which series, how many notes are in circulation, what is the value of the notes in circulation, when were they issued, should I demonetize them, what is the impact of that demonetization, then make a comprehensive recommendation which the government will consider, look at the social and economic implications of that, and then decide. That was not done in this case. They simply said 500 and 1,000 will go. That is the first submission.
Then you'll have to tell us what is the object of demonetization in an economy.
Well, I said that in the affidavit. According to me, my submission is there are only two circumstances.
Those objects.
Only two circumstances, and I'll show Malad from the Reserve Bank, history of Reserve Bank, what was the comment of the then governor in 46 and 70. I will show it in a moment. Demonetization is resorted to in a
Exceptional in an exceptional circumstance.
Two circumstances.
Two circumstances. One, my lord, the note is practically unusable. Suppose we had a 50,000 rupee note. What is the use of such a note? Therefore, that can be rendered no longer legal tender. The other is when hyperinflation has reduced the value of the note to practically nothing. It's a scrap of paper. At one point of time, Zimbabwe, 1 million, whatever currency there, could not even buy a cup of tea. What's the use of a 1 million? I'm a millionaire, you can say, but you're practically useless. Therefore, my lord, you have to carry bags of currency to buy food. Your lordships must have seen the picture. Zimbabwe was the worst example, but similar things have happened in Argentina, and now it's happening in Turkey. You have to carry boxes of currency before to do a transactive business. They are useless. So you demonetize them and substitute it by new currency. Therefore, my lord, my first submission is that. What is it? Now see the 811 notification, which is in, my lord, in the writ petition at page 13, volume 1, page 13. So your lordship has the notification 3407E, SO number 3407E. It's in volume 1 of the writ petition.
8th November 2006.
8th, 11,
November.
26.
There are many 8th Novembers. This is SO 3407E.
Yes, that's what we have.
That's the one. My lady has got it, my lord justice.
2020. In this
No,
compilation,
it's going to be Vivek Narayan petition. Writ petition.
Page 23.
yes,
Now kindly see,
3407.
So 3407E.
yes, 3407. Now kindly see, my lord, I'm skipping the preamble for the time being.
Lord,
No, no, no,
we have
objective.
prepared, my lord, a compilation of all the notifications in connection with this, my lord, particular.
That will be better, I think, because we need not refer to all the.
Yes. My lord, if your lordship pleases, my lord, we can file it and give copies to my learned friend also.
You are not yet filed.
It has not yet been filed. In fact, my lord, not all of them are on record, but they are just notifications. So they are, my lord, legal, statutory document.
In this compilation, it is at what page, Mr. Gupta? Mr. Gupta? Mr. Gupta?
Yes, that's fine.
3407. Indexing is.
There is an index, my lord. And all the notifications, my lord, are in respect of, because there were several notifications from time to time.
Page 3 perhaps, English version.
Yes, my lord. The particular one which my learned friend is now referring to is 8th of November 2016, the first. 1 to 4. Lord, my learned friend can continue to use whatever copy he is using.
I have no objection. Please hand up to everybody.
Yes, we have done that.
It will be convenient for us to refer.
Please have it. I'll get a copy of it.
Yes, we have. Yes, Mr. Chair.
Now, please see the first paragraph. Whereas the Central Board of Directors of the Reserve Bank of India, hereinafter referred to as the board, has recommended that bank notes of denominations of the existing series. Well, existing series means all series existing on that date. Existing series of the value of 500 rupees and 1,000 paragraphs below. Now, therefore, an exercise of the powers conferred by subsection 2 of section 26, the central government hereby declares that the specified bank notes shall cease to be legal tender with effect from the 9th of November. So, existing series of the value of 500 rupees, hereinafter referred to as the specified bank notes. And all of that is declared no longer legal tender, which means all the series of notes of 500 and 1,000 are declared. The effect is the same as the 46 and 78 legislation intended, except that instead of making separate legislation, they resorted to section 26. Question is, does 26 give you the power? According to me, 26 does not give you that power. And it only gives you a power to declare any specified series, series 1, series 2, or series A, series B. And you can't declare all existing notes of all series of that denomination as illegal tender. This is the first submission. The second submission is, Your Lordship will kindly have that affidavit which I was reading. I had read paragraph 10 on the first proposition. I'm on the second proposition. 87, that affidavit of mine. Arbitrary power on the executive government and is liable to be struck down on the ground it violates Articles 14, 19, 21, and 300A. It will amount to an impermissible delegation of legislative power. Pertinently, the demonetizations of 46 and 78 were done through separate acts of parliament. Under Articles 14, 19, 21, and 300A, life and livelihood are protected against arbitrary executive action. It is submitted that Section 26(2) must be read down in the manner submitted in paragraph 10 above. If not read down, it is submitted 26(2) would be unconstitutional. If not read down, Section 26(2) will confer an unguided, uncanonized power. On a plain reading of Section 26(2), it is obvious that there is no policy and there are no guidelines in the said provision. What matters shall be taken into account and what matters shall not be taken into account are not specified in 26(2). If a drastic power of demonetizing currency notes of all series in certain denominations was intended to be conferred upon the executive government, Parliament should have laid down what are the relevant matters that should be taken into account and what are the matters that should be eschewed by the executive government. In the absence of any policy or guidelines, it is submitted that Section 26(2), if not read down in the manner suggested above, would be unconstitutional. Now, kindly look at 26(2), Mala. Any number of times we read it, there is no guideline at all. It simply confers a power. Now, please see, Mala. On the recommendation of the Central Board, Central Government may declare any series shall cease to be a legal tender. What is the guideline for that? What is the guideline Parliament is giving?
There is a inbuilt safeguard that it can't exercise the power itself. It has to do it on the recommendation of the board.
Correct, man. But what should the board consider? What should you take into account? Well, I asked the question last time. 86.4, suppose can you withdraw 99% of the currency? And stretching it further, can you withdraw 99.9% of the currency? Suppose they had done 100 rupee notes also, it would have virtually been 99% of the currency. Well, that kind of power is available to an executive government without parliamentary oversight and supervision. And even if Parliament does that, we will challenge that law as an unreasonable and arbitrary law. But be that as it may, that is not the case here. Parliament did not do it. Parliament was kept in the dark until the notification. Yes.
Are you giving up your first argument now?
No, no.
Because you are, no, please listen.
Prejudice.
Please listen to us. You are, see, if we say any to all, maybe you can't withdraw all currencies.
Yes.
Now, if we interpret any to anything of their choice, then of course there is a there needs to be, it requires some guidance.
That's why I'm saying, Malad, if you don't read it down, it will be unconstitutional. If you read it down, then any particular series, your lordships will examine what were the considerations, why you withdrew series A and left series B. We can have some, I repeatedly say, if you don't read it down in the manner specific in my paragraph 10 of my affidavit, then my second ground is this is unconstitutional. If you read it down, the question doesn't arise me. If your lordships read it down in the manner that I have submitted, suggested, then 26(2) may be valid.
But
then
in that case, for withdrawing any particular series,
yes,
it can be permitted to be done arbitrarily.
no, I'll tell you, Lordship, why. Now, if you've got 5 series of notes issued in 70, 80, 90, and 2000, then RBI will recommend 70 series may be withdrawn. Then there will be some material to show why the 70 series was chosen and not the 80 series and the 90 series. Some reasons will be recorded. And therefore, those reasons can be examined to say they are completely extraneous reasons. That will show that the power has been exercised after taking into account relevant matters and eschewing irrelevant matters. If you allow such a wholesale power, then nothing need be taken into account, nothing need be eschewed. That power is an absolute power to declare all series of notes of 500 and 1,000 is no longer legal tender. You don't have to take into account anything and eschew anything into account. Eschew anything. You can exercise the power arbitrarily. But to among series of 500 rupee note, you have to pick one or two for whatever reason. The fact that you are narrowing your choice to a specified series or a particular series itself is a guideline that you can't do all, you have to choose one or more. And then when you apply your mind to that, you have to give reasons why you're doing, what factors you took into account, what factors you eschewed. If that is the nature of the power, that power, according to me, is a constitutional power, not an arbitrary power. But if you read 26(2) to mean all series of any time can be withdrawn, that is a completely arbitrary power. If you're giving that power, then prescribe the guidelines there. Now look at, Lord, I'll hand up a compilation. Your Lordship may keep it. This has some very interesting information. How does the RBI withdraw some series?
Yeah.
Just look at this compilation. This is in 2014. They are withdrawing notes issued prior to 2005, 9 years later. As you are aware, RBI has been following a policy of phasing out certain series of banknotes from time to time. It has now been decided that all old series of banknotes issued prior to 2005 will be completely withdrawn from circulation. Accordingly, the following plan of action has been formulated. All older series of banknotes, well, kindly see use the word old and older series. Older series of banknotes issued prior to 2005 would be acceptable for all kinds of monetary transactions only till March 31. They're giving 2 months. Thereafter, the public will be required to approach bank branches which would provide them exchange facilities on an ongoing basis. These notes will continue to be legal tender. From July 1, to exchange more than 10 pieces of 500 and 1,000 notes, bank branches should obtain from non-customers proof of their identity. A public notification informing public of the exercise and soliciting their cooperation and enabling them to identify the older series is issued separately. Please issue suitable instructions to your branches to provide exchange facilities to members of public and to stop reissue of the older series of banknotes issued prior to 2005. Notes of such series tendered over the counters may be sorted immediately and deposited in the currency chest under the linkage scheme forwarded to the nearest issue. Please advise. This is application of mind, exercising your limited power.
Mr.
This is
Chidambaram,
not
how
even declared.
could it been traced to 26-2 because these are power exercised by the RBI.
This is not under 26(2). I'm saying this is how normally the RBI withdraws old series when new series notes are done. Does not declare it to be illegal.
Because there's no discontinuity.
Not declared to be an illegal tender. This is what, if you want to declare that note as illegal tender, you have to go to the government. RBI itself can do that. Withdrawing old series can be done. This is how it's done. After 9 years, 10 years, old series of notes are withdrawn. If they wanted to do the other step of declaring it illegal tender, they have to go to the government. In 46 and 78, they wanted to do both. All series will be withdrawn and declared illegal tender. Therefore, they went to separate legislation. Now, the next one also similar. In 2016, this is only about 5 months before demonetization. Please refer to our circular dated so and so. As you all may be aware, from January 2014, the earlier notification, pre-2005 bank notes are being withdrawn from circulation, and through sustained efforts, a large percentage of these notes have since been withdrawn. A small percentage of these notes, however, still remains in circulation. On a review thereof, it has been decided that from July 1, the facility for the members of public to exchange the pre-2005 bank notes will be available only at the following offices of the RBI. Pre-2005 bank notes will continue to remain legal tender. You are advised to suitably guide. In phases, my lord, without causing any inconvenience, RBI withdraws old notes, gives sufficient time for public to exchange it, and then a large percentage is withdrawn. It restricts the exchange counters to a few cities in 2016, but says it will still be legal tender, the few notes that will remain. This is, my lord, according to me, a non-arbitrary, reasonable exercise of power. If you wanted to do the second step of declaring it no longer legal tender, the RBI would have to make a recommendation to the government of India. Neither you don't withdraw the notes and declare it legal tender. You simply, by notification, declare all series of 500 and 1000. It's an arbitrary, uncanalized, unguided power, which no executive government should have. And 26(2) does not confer such a power.
See, this withdrawal of old series is not demonetization.
It is not, no. I said
It continues, therefore,
continues to be legal.
not equate this with
No,
demonetization.
this
This is only for the purpose of showing application of mind withdrawal.
there are two steps in
Yes.
demonetization. One is withdrawing the notes. Other is declaring it illegal tender immediately.
Yes.
Two steps. Normally, what the RBI does is the first step. It can do on its own, my Lord Justice, as you mentioned. You can do it on your own. You don't have to go to 2016. If you want to do the second step, you have to go to the government and say the remaining notes will be illegal, no longer legal tender. But that power must be exercised reasonably in a manner that it's not disproportionate burden on the people. In the past, in modern times, RBI has taken only the first step. It is never recommended it should become illegal tender. On the two occasions, you wanted to withdraw all the notes and declare it no longer legal tender, you thought fit to go to a separate legislation. This time, when you want to withdraw all the notes of 500 and declare it no longer legal tender, you make a notification. Where is the guideline for that? That is the point.
Yes.
So 26(2) does not confer that power. And I'm sure, my lord, the government will plead that 26(2) confers that power. I would request your lordships, my lord, the highest court of the country, not to read that power in 26(2), But that is an arbitrary, drastic power which no executive government should have. If it wants such a power in 26(2), then 26(2) itself must prescribe what shall be taken into account, what shall not be taken into account. These two examples I gave of 2014 is a reasonable, considered exercise of power without putting people to distress. If you wanted to take the next step, you must have separate legislation, like in 46 and 78.
But in this notification itself, they have tried to justify it on the ground of fake currency.
Ramila, it's interesting to see what the RBI felt in 1946 and 17. The small compilation which I gave to your lordship, please come to Reserve Bank of India. This is from the RBI's own publication. Page 5. Currency and coinage matters. Demonetization of high denomination notes. Kindly come to over the page. Monetary management and allied issues. It is not known when the government, this is history, Milord, but history throws light on what the RBI thinks. It is not known when the government authorities started thinking on the demonetization measure. But the final consultation with the governor and deputy governor Trevor took place towards the end of 1945, when Mr. N. Sundaresan, Joint Secretary, called for a discussion, for which he had earlier prepared a note, and the drafts of the ordinances to implement the scheme. That is a 46 ordinance. According to a note recorded by Mr. So-and-so, it would appear Reserve Bank authorities were not enthusiastic about the scheme. The governor stated that the finance member had given him the impression that the scheme would be launched only when there was sort of an inflationary spiral. The governor saw no special signs of such situation. It appeared to him that the main object of the scheme was to get hold of the tax evader. The governor wondered if this would be called an emergency to justify the promulgation of an ordinance just before the newly elected Legislative Assembly met. Governor wanted government to be satisfied that there was no harassment to honest persons. As a currency authority, the bank could not endorse any measure likely to undermine the confidence in the country's currency. The governor at that time was Dr. C.D. Deshmukh. That's noted later. The governor agreed that about 60% of the notes would be in Indian states, and so cooperation with the state governments was very necessary. Apparently, he had some doubts about this. According to Mr. Sundaresan, the ideal thing was to block high denomination notes, but this course was not favored by either the finance member or the government. Subject to these observations, the schemes drafted by Mr. Sundaresan was considered by the government to be theoretically all right, but he and the deputy governor pointed out the considerable administrative difficulties involved in covering nearly 5,700 offices of scheduled and non-scheduled banks. The governor's concluding remarks, as recorded by Mr. Sundaresan, were as undone. Sri Chintaman Deshmukh felt that we may not get even as much as 10 crore as additional tax revenue from tax evasion, and that the contemplated measure, if designed to achieve such a purpose, has no precedent or parallel anywhere. If value is going to be paid for value, like in our case, Milord, value for value, no matter whether such value is in lower denomination notes, it is not going to obliterate black markets. His advice is that we should think very seriously if for the object in view, as he deduces from the declaration form, whether this is an opportune time to proceed with the scheme. Provided government are satisfied on point 1, sparing harassment to the unoffending holders, and 2, a worthwhile minimum of results in the shape of extra tax revenue. He does not wish to object to the scheme as drafted. The government wished to proceed with, notwithstanding the administrative difficulties. The government went ahead with the scheme. On January 12, 2 ordinances were issued, demonetizing notes of denomination value of 500 and above. The first ordinance required all banks and treasuries in British India, etc. All that is, Milord, the practical aspects of it. And the last paragraph, the measure did not succeed, as by the end of 1947, out of a total issue of 143 crore of high denomination notes, notes of the value of 134.9 crore were exchanged. Thus, notes worth only 9 crore were probably demonetized, not having been presented. The results of the demonetization measure were summed up by Sir Chintaman in his Dadabai Navroji lecture delivered in February 1957 as undone. It was not a revolutionary measure, and even its purpose as a minatory and punitive gesture towards black marketing was not effectively served. There was no foolproof administrative method by which a particular note brought by an individual could be proved as the life savings of the hard-working man who presented or established as a sordid gains of a black marketer. Another loophole of which considerable advantage was taken was the exemption of the princely states from scrutiny or questioning when such notes were presented by them. In the end, out of a total issue of 143.97 crore, notes of the value of 134.9 crore were exchanged up to the end of 1947, as mentioned in the report. Thus, notes worth only 9.07 crore were probably demonetized, not having been presented, with more of a conversion, varying rates of profits and losses than demonetization. There was an echo of this measure in 1948. In September, while government were considering anti-inflationary measures, rumors spread that 100 rupee notes would be demonetized and that bank deposits would be frozen. The Prime Minister had to make a statement in the legislature categorically. I can only infer when the RBI governor was very reluctant to exercise the power under 26(2), they devised the scheme and got it done by an ordinance in 46. All the notes. And even that scheme, the RBI governor said, is not going to help me. As against 147 crore of value of currency in circulation, We have here 17 lakh crore. The multiplier is a mind-boggling number. As against 147 crore, we have 17 lakh crore. And your lordship sees practically 90 odd % came back to the Reserve Bank then. Today also, 99% of the currency came back. In 1946, 1978, there was another government. Kindly come to page 9. Dr. I.G. Patel, another very distinguished economist, who's head of the London School of Economics for a while. Now, kindly come to page 10. This is from the RBI's website. I've downloaded it. Its book is published called The History of RBI. Page 10. The second paragraph. According to the ordinance, which was replaced for the Act, all high denomination bank notes ceased to be legal tender in payment on account of any place after 16 January 78. The demonetization of 1978 was the second such exercise in India, the first one having been conducted in 1946. Governor I.G. Patel was not in favor of this exercise. According to him, some people in the coalition in the government saw demonetization as a measure specifically targeted against the allegedly corrupt predecessor governments or government leaders. Patel recalled in his book, Glimpses of Indian Economic Policy and Insider's View, that when Finance Minister H.M. Patel informed him about the decision to demonetize high denomination notes, he pointed out that such an exercise seldom produces striking results. Most people who accept illegal gratification or are otherwise the recipients of black money do not keep their ill-gotten earnings in the form of currency for long. The idea that black money or wealth is held in the form of notes tucked away in suitcases or pillowcases is naive. And in any case, even those who are caught napping or waiting will have the chance to convert the notes through paid agents, as some provision has to be made to convert at par notes tendered in small amounts for which explanations cannot be reasonably sought. But the gesture to be made can produce much work and little gain. Demonetization was a sensitive issue and secrecy was imperative, not only for anecdote, for historical. I'll read this paragraph. R. Janakiraman, a senior official in the Chief Accountant's Office in the Reserve Bank, was asked by some officers of the Government of India over the telephone on 14 January to go over to Delhi immediately on some urgent work. When he inquired the purpose of the visit so that he could go prepared, the official stated that matters relating to exchange control would need to be discussed and that he should leave for Delhi on his own. Janakiraman, however, took along with him M. Subramanian, a senior official of the Exchange Control Department. On reaching Delhi, it was revealed government had decided to demonetize high denomination notes and was required to draft the necessary ordinance within 24 hours. During this period, no communication was allowed with the bank's central office in Bombay, since such contacts could give rise to speculation. Janakiraman and Subramaniam made a request for the 1946 ordinance on demonetization to get an idea of how it was drafted, and the request was acceded by the Finance Ministry. The draft ordinance was completed and scheduled. It was then finalized and sent for the signature of the President of India in the early hours of 16 January. The news was to be announced on All India Radio's news bulletin at 9 a.m. the same day. It was given as a flash. Now, this is how that the ordinance was passed. One official saying you can't communicate with anyone, draft an ordinance, promulgate it, and then the law is passed. At least the law is passed. There's a debate in Parliament. Here, my lord, substitute 14 January and 16 January. By 7th November letter, 8th November demonetized. I'll come to that one. They are still holding back 4 documents, which I implored your lordships to call for and do. The 7th November letter from government to the RBI. The agenda note placed before the RBI board. The minutes of the RBI board and the recommendation for the actual cabinet decision on 8th November. It was all done in a matter of, my calculation shows, about 26 hours. The letter reached the RBI on 17th at about afternoon, post-afternoon, 7th post-afternoon. The RBI board was called, presumably by telephone, to meet in Delhi on the 8th November. They meet at 5:30. By 6:30 or 7, the recommendation is taken by hand to the cabinet. The cabinet is meeting, waiting, and I've said so, waiting, and then the Honorable Prime Minister goes on television and announces. Let's look at page 12, last paragraph.
Yes, we have.
On the day following demonetization, two noted economists, Professor C.N. Vakil and Dr. Brahmananda, expressed the view that the measure would not have had any enduring effect on money supply, prices of necessities, and problems like low savings, acute poverty, unemployment, and industrial relations, as the high denomination currency notes formed only a small proportion of the total money supply. They were the authors of the memorandum titled Semi-Bomb Law, submitted to the Union government for tackling inflation. Well, now, kindly see how the board should meet. There are regulations framed, next page, regulations framed called Reserve Bank of India General Regulations, which govern the meeting of the Central Board of the RBI. Finally come to Regulation 8 in Chapter 3 at page 17. Ordinarily, not less than 1 clear month's notice shall be given for each meeting of the Central Board, and such notice shall be sent to every director to his registered address. Should it be found necessary to convene an emergency meeting, sufficient notice shall be given to every director who is at the time in India to enable him to attend. No business. Finally come to 3. 4 directors, of whom not less than 3 shall be directors nominated under 8(1)(b) or 8(1)(c) of the Act, shall form a quorum for the transactions. Now kindly look at 8(1)(b) and 8(1)(c) again. 4 directors, of whom not less than 3, 8(1) of the Act, 8(1)(b) and 8(1)(c) of the RBI Act, not less than 3 shall be directors nominated under 8(1)(b). 8(1)(b). So there's no disclosure who attended the meeting, whether the quorum is there, no disclosure by the government, when the notice was given, did they have sufficient notice to travel to Delhi, how many met, nothing has been disclosed in the counter affidavits.
Mr. Chidambaram, Rule 8 starts with the expression ordinarily.
Correct, Manu?
Yes.
I'm not disputing, but quorum is not ordinarily, quorum is mandated. Each one notice of one clear month is ordinary. Emergency meeting, sufficient notice. 8(3) is a mandatory quorum. 4 directors shall form a quorum.
Yes, yes.
That is not ordinarily. They have to disclose who attended the meeting. Sufficient notice to give every director in India to enable him to attend. That is an emergency meeting. Let's assume this is an emergency meeting. We should give time to people to attend. And how many attended? My lord. That's all. And then the next, italics 4, this is very important.
Out of 4, 3 have to be either from 8(1)(b) or C.
Yes, I agree. But who attended an 8(1)(b), who attended an 8(1)(c) is not disclosed to your lordships. We don't know who attended. All I know is 8(1)(c), 7 vacancies. There were 3 people in 8(1)(c) and 4 people in 8(1)(b). Out of the 7, did 4 attend or 3 attend? We don't know. And look at 4, my lord, that is more important. A copy of the proceedings of each meeting shall be circulated as soon as possible thereafter for the information of the directors and shall be signed by the chairman at the end of the next succeeding meeting. So minutes should have been kept. What happened at that board meeting? What was the agenda and what was the decision? Nothing has been disclosed to your lordship. Last time your lordships were pleased to observe that keep these documents ready. If necessary, we'll look into it. I had specifically mentioned 4 documents. 7th November letter from the government to the RBI, the agenda note with whatever annexures material placed before the board, the decision of the board, and then the recommendation of the RBI board to the government. And then, of course, the cabinet decision. Nothing has been supplied. Not the letter, not the agenda, not the minutes. Therefore, my lord, I have completed my second submission that such a power is not available in 2016. If it's not read down, then 26(2) itself would be unconstitutional. I'll cite the case law at the very end. Now I'm on paragraph 11 I've completed. I'm on the third submission, paragraph 12. The decision-making process in the present case was deeply flawed. Affidavit of page 8, para 12. The decision-making process in the present case was deeply flawed and can be judicially reviewed by this honorable court. Contrary to the scheme and procedure contained in section 26(2), the process was actually reversed. The roles of the RBI and the government were reversed, and I'll show from their own affidavit. On a plain reading of the language of 26(2), there is only one procedure that can be followed, and the procedure was mandatory. Now, kindly keep in mind, sole authority for currency notes is the RBI. 22, 23, 24, 25, and 26 of the Act. The proposal for demonetization must be initiated by the RBI. This is my submission. the Central Board of the RBI must make a recommendation. It is implicit that the Central Board, consisting of members specified in Section 8 of the RBI, would consider all relevant material, weigh the pros and cons, consider the impact on the people of the country and the consequences on the economy before making a recommendation. Upon receipt of the recommendation, the central government may take the decision to declare certain currency notes as no longer legal tender. The use of the word may means central government, after considering the matter carefully, may accept the recommendation or reject the recommendation. Since the central government has the option to either accept the recommendation or reject the recommendation, it is implicit that the central government must apply its mind, take into account all relevant factors, eschew irrelevant factors, consider the impact on the people of the country and the consequences to the economy before taking a decision. It is implicit in Section 26(2) that adequate time and attention must be devoted by both the central board and the central government before a major step like demonetization is taken. In the present case, the facts and the records will show that the procedure with the implicit obligations was abandoned and the process contemplated under Section 26(2) was turned on its head. The proposal, no adequate care and consideration was bestowed on the crucial matter by the RBI, and as will be presently demonstrated, no time at all was devoted by the central government before it took the decision to demonetize the notes. It is submitted. The following are the crucial documents which must be produced before this honorable court. The letter of the central government dated 7/11, the agenda note dated 8/11, if any, placed before the Central Board of RBI, and the relevant research papers, background notes, information, data. C, the recommendation of the Central Board dated 8/11 to the central government. D, the note for cabinet, if any, that was placed before the cabinet on 8/11, the actual decision of the cabinet. The petitioner learns, verily believes and states that the letter of the central government dated 7/11 was received by the RBI in the afternoon, early evening at its office in Mumbai. The governor
That you
of the
already told
RBI,
Mr. Chidambaram.
under his instructions,
That you already told us. Sequence.
I don't have to read it, Miller. I've told you much. This paragraph 3, I've told you much. Quote, it is submitted that on the above facts, the only conclusion that can be drawn is there is no application of mine either by the RBI or the Central Board or the Cabinet of the Government of India. The procedure followed was premeditated. In fact, the procedure that was followed was in total violation of the procedure contemplated in 26(2). The decision-making process was premeditated, rushed, betrayed a non-application of mind, and was deeply and fatally flawed. It is submitted that full information and relevant material were not placed before the Central Board. As will be explained later, the enormous consequences of the impugned demonetization were not known to the Central Board, especially the directors falling under categories H, 1, B, and C, and perhaps even D. No agenda note containing all the relevant material was placed before the meeting of the Central Board. Further, the recommendation of the RBI dated 8/11 to the central government did not contain the full information on the relevant material. Hence, the members of the cabinet did not have the full information on the relevant material, since apparently a decision had already been taken to demonetize all series of 500 and 1000. The note for cabinet, if any, placed before the cabinet did not contain the full information. In the light of the facts stated above, arbitrary, capricious decision not taken in good faith and normative. But unless this material is available to your lordships, it will be difficult for your lordships to come to a conclusion whether there was an application of meaning. What was the material? I'll show that emanated from the government. I'll show from their affidavit. But my lord, in the absence of this crucial documents and information, which is not put in the public domain, it is 6 years now. Maybe it will come in a RBI series volume 10 years later. The point is, today I will not be challenging it before your lordships, and your lordships must know what did you look into. What was the information placed? Well, this is not a guess, this is an informed guess. Nobody was told. Lordship doesn't have to accept my word for it, but I know that nobody was told 86.4% of the currency will be withdrawn. These numbers were simply not available either to the board or to cabinet. Nobody was told that 500 rupee and 1000 rupee notes accounted for 86.4% of the currency. Remember, my lord, in 46 and 78, it was 7 point something and 0.46%. Yeah, you withdrew the entire currency, practically all the currency. Now, my lord, now kindly see.
Mr. Chidambaram, Reserve Bank of India is here. He has to answer.
I'm sure they'll answer. They will answer. They will answer more tellingly if they place the document for your lordship.
Let's see what he is going to say.
What was considered? What was the agenda? No. Well, there are Union of India.
906 counter affidavit.
No, wait. They filed 3 counter affidavits. One
in 2016.
way back in 2016. One in 2018. And a short counter affidavit after I filed the additional. I'm on the second counter affidavit they filed in 2018. This is my lord, counter affidavit on behalf of the Union of India in WP 906. It's dated October 2018.
6-volume counter affidavit. First volume of 6-volume counter affidavit.
6 volumes are.
Volume 1 of 6. Page 30.
Page 30, I'm reading from page 37. '37, the headline rationale behind demonetization, its implementation. This is Union of India's. Paragraph 29. That in the last few years, the Reserve Bank, in consultation with the Government of India, had been working on introduction of new series of banknotes. Now, this is an admission that banknotes are issued in series. It includes changes for improving existing security features, introduction of new security features, and new design features, including new color scheme, new sizes, besides a new theme. The primary objective behind this entire exercise is to secure our banknotes against counterfeiting. The Reserve Bank of India also embarks in January 2014. I read to your lordship the circulars on a program to withdraw all the notes issued before 2005 withdrawal of old series notes periodically is a standard international practice. This is what I submitted. In parallel, Government of India had taken several steps to curb black money and combat terrorism. There were reports by intelligence and enforcement agencies that availability of the then existing high denomination banknotes made it easier for black money holders, and counterfeited notes in high denominations were being used for terrorist financing. This is the crucial paragraph. The Government of India and the Reserve Bank consider that the introduction of new series of notes could provide a very rare and profound opportunity to tackle all the three problems of counterfeiting, terrorist financing, and black money by demonetizing the banknotes in high denominations of 500 and 1,000, or by withdrawing legal tender status of such banknotes. The Government of India, therefore, on 7/11/2016, advised the Reserve Bank that to mitigate the triple problems of counterfeiting, terrorist financing, and black money, the Central Board of the Reserve Bank may consider withdrawal of the legal tender status of the notes in high denominations of 500 and 1,000. It was advised in that letter that cash has been a facilitator of black money since transactions made in cash do not leave any audit trail. Elimination of black money will eliminate the long shadow of the ghost economy and will be positive for India's growth outlook. They also observe in the last 5 years, there has been an increase in the circulation of 500 and 1,000 notes and an increasing incidence of counterfeiting of these notes. There have been widespread reports of the usage of fake Indian currency notes for financing of terrorism and drug financing. The fake Indian currency notes have their origin in a neighboring country and pose a grievous threat to the security and integrity of the country. Hence, the government recommended that the withdrawal of the legal tender character of these notes is apposite. The Government of India advised the bank to place these matters immediately before the directors of the Central Board consideration in terms of provisions of 2016. But stopping here, it's very clear. Government advised, government recommended, government advised the RBI to place these matters in. It started with the government. They don't say anything to the contrary. Then para 33. The Central Board of the Reserve Bank met on 8/11 to consider the government's advice. The board was informed that a summary measure with high and lasting impact in the form of withdrawal of legal tender character of these high denomination banknotes to contain the menace of government notes, mark my lord, was proposed by the government. RBI board was informed that this step is proposed for the government. It is also presented that such a proposal could not have come at a more opportune time than coinciding with the introduction of the Mahatma Gandhi new series of notes. With these, the existing bank notes can be summarily withdrawn and the new design notes with more counterfeit resistance features be introduced. Thereafter, Government of India, on the recommendation of the Central Board of the Reserve Bank, withdrew the legal tender status of banknotes of 500 and 1,000. Since secrecy and confidentiality were the critical requirements of this decision-making process, preparations for arranging banknotes of new series in full measure was impossible. Therefore, when schemes started, the demonetized banknotes could be exchanged with new available banknotes, along with a continuous supply being made from the bank note printing presses. Reasonable restrictions on withdrawal were put in place based on the availability of stock of currency notes of various denominations, fast utilization pattern, and considering the needs of the common persons so that the hardships are minimized, keeping in view equitable distribution of available cash. These restrictions were only on cash withdrawals. The rest a lot about the scheme it's absolutely clear in my respectful submission that the original recommendation came from the government. It is described by the government as advice. It is described by the RBI as a proposal from the government. And on that, the RBI acted. This is reversing the process. It cannot start with the government. The government does not have the kind of information and data required to gauge the intolerable or disproportionate burden it will place on the people. Only the RBI, as a sole authority on currency, has that information. Nobody in government has the up-to-date information about the value of currency in circulation in each denomination, how much is of the banks, how much is of the public, and in what denomination, what currency is there. Nobody has that information. It is a dynamic information. It is collected every day by the RBI and published, my lord, once a week in the weekly supplement. The government does not have that information. Besides, my lord, the impact on the people is not available to the government. It's certainly not available to anybody outside the finance ministry. Within the finance ministry, it will be available to a small number of officers and the minister. It's certainly not available to the cabinet. Therefore, my lord, advisedly, Parliament law says the recommendation must start with the RBI. Then RBI must justify its proposal. Government is the authority to take a decision after having all the full information. Well, according to me, this implies the following obligations. One, I've said so in affidavit. One, it requires data and material with the RBI in the form of an agenda note placed before the board. But today, they have filed 6 volumes of data before your lordship. What was the data placed before the board? The board has got laymen. Laymen means in the sense that they are experts in their field, but they are not familiar with monetary economics or currency. They are not familiar with that. They must be told what is the information you have. Then, my lord, that requires time to collect the data, time to draft the note and place it before the board. Then the RBI board must have time to reflect on it. It can't be called at 5:30 and asked to take a decision at 6:30. Where is the time for reflection? There's no time was given for reflection. The board met at 5:30 and the recommendation went at 6:30. I've asserted it, and that ties up with the information available in the public domain, because the cabinet decision was announced at 8 o'clock. So they had less than an hour to digest all this information and make a recommendation. Thirdly, my lord, the government must have that information and must reflect on the information. Where was the reflection? The finance ministry did not reflect upon it. It went straight to the cabinet. No other minister had any information. And at the cabinet was a note placed before the cabinet incorporating the material and the recommendation. We don't know. Nobody has told your lordship that. The cabinet is already meeting. I've said so. Cabinet is already meeting. And this recommendation is carried by hand to the cabinet. And my lord, evidence in the public domain shows that the decision was taken. The cabinet ministers were asked to stay back in the cabinet room while the Prime Minister went for a broadcast, telecast. The telecast was pre-planned because on 8 p.m., all the channels broadcast the speech. All the channels. Every language channel broadcasted at 8 o'clock. Therefore, my lord, it was booked in advance that the Prime Minister will address you. Obviously, when the Prime Minister addresses, it is a duty of every channel to broadcast it, and to the extent possible, a duty of every citizen to listen to the speech of the Prime Minister. So 8 o'clock, the Prime Minister announces that effective midnight today, 500 and 100. What is the deliberation? What is the reflection? Is this the decision-making process? If this decision-making process is upheld, my lord, it will mean chaos in future. Adequate secrecy is important. I'm not denying that. But secrecy coupled with reasonable devotion of time and mind to the issue before you. It can't be, my lord, even war is declared in secret, but enough time and application of mind is there before war is declared.
It is not in public domain.
Okay, Pandava?
Such information or such preparation is not in a public domain.
I'm not saying it is in the public domain, but it must be in the domain of the board. The board must have information. The cabinet must have information. It can't be it can't be in 24 hours. Well, I would implore you.
History repeats. In 1978, Janaki Raman.
Yes. But there at least there was a post facto legislation in Parliament. Replaced by ordinance, replaced by a debate, and that technically Parliament could have overturned the ordinance also, or amended the ordinance.
The same, they were preparing Janaki Raman and Subramanian, they drafted the ordinance. It was signed in the morning,
Ordinance.
and 8:30 it was published
Yes,
in a speech at All India Radio.
correct. But at least it's backed by legislation subsequently. The Parliament must have debated it.
So ratification of the Executive Act by the Parliament.
No, but it can turn it down also. Technically, it can turn it down. In 1978, my lord, there was no certainty any law will pass. The lordship recalls 1977 to 79. There were two governments. One was replaced by the other. They were speaking in different voices. So in 1978, there's no certainty an ordinance will be ratified or passed. Be that as it may, what is the material place? What is the application of mind? What is the deliberation? That must be disclosed. Therefore, the inference is it was all premeditated and it was pushed through in less than 24 hours. The same story is repeated in the last affidavit filed on 16th November 22, a short affidavit by the Union of India. Even after we point out in our 5th November affidavit that there is no deliberation, no application of mind, not enough time, not sufficient mind applied, they reiterate it.
November 2020.
Yes, 16 November 22.
It's another one,
No,
21st November.
RBI. We'll come to the RBI later. We are on Union of India. That is in my Divan's case, specific to that. Now, finally come to paragraph 14, page 7. Even after we point out on our affidavit of 511, which I read to your lordship, but this was all kindly come to paragraph 14. The steps taken towards this have been recaptured by the affidavit filed by Union of India, by the paragraphs 31 to 34 at pages 38 to 41, which are what I read to you. They reiterate. Then they say, kindly come to paragraph 16. Secrecy and confidentiality were critical requirements of this consultation and decision-making process. That's all, my lord, they say in this affidavit. They reiterated what they said earlier in para 31 to 34. And I would therefore submit, my lord, I would submit my ground paragraph 12. The decision-making process is deeply flawed. This is not a fair decision-making process, and therefore your lordships can review it. Then paragraph 13, my fourth ground. Paragraph
Start at 2 again.
Very well.
Your lordship may record my statement that the demonetization is as per the Reserve Bank of India Act 1934. There is no irregularity or illegality.
We'll consider, let him complete the argument.
Only 1 week time may be given to the present petitioners to deposit the bank a small amount of 30,000 in their respective bank. My lord.
Wait, sir, we are in the midst of argument. Please wait.
As your lordship, yeah.
Please wait.
Grateful, my lord. Grateful, my lord. We are grateful, my lord.
10:42.
But I was on paragraph 13 of my additional affidavit, proposition 4, 10, 11, 12 I've completed. Paragraph 13 at page 12. The recommendations of the RBI for demonetizing 500 and 1,000 rupee notes did not consider relevant factors and eschewed irrelevant factors before making the far-reaching recommendation. The consequences of demonetizing all series of notes were not considered by the central board, the RBI, or the government. As a result of demonetization, 86.4% of the currency value was declared no longer legal tender. In terms of absolute value, the amount to 15,44,000 crore out of the total of 17 lakh crore. 2,300 crore distinct notes have become illegal. The most used currency notes in 2016 were obviously 500 and 1,000, where they accounted for 86.4. Since they were demonetized overnight, millions of people were left with no valid money to buy food, milk, or even medicines. Thousands of families went without a meal in 9/11, 10/11. Voluntary organizations had to distribute free food. Since the invalid notes could be exchanged in specified bank branches, it has been estimated that on average 11 crore people stood in queue every day to exchange notes. Wholesale markets were shut down. Village fairs or shanties held once a week were stopped. Retail outlets reported a calamitous drop in sales. Industrial hubs like Tirupur, etc., came to a complete halt. Wages were not paid for several weeks. Casual laborers represent 33% of all employed persons in India, and the number is estimated at 15 crore individuals. All of them were without jobs overnight and consequently without daily wages. Street vendors like vegetable sellers, fruit sellers, tea stalls, etc., could not ply their trade and went without income for several days. It was a sowing season, November. Since DCCBs were not allowed to exchange currency notes, millions of farmers were unable to withdraw or deposit money. They could not draw money to buy seeds or fertilizers. Moreover, their produce suffered a huge crash in prices, as seen in the table below. Well, these are official NSO statistics from the Ministry of Consumer Affairs and Commerce. Wholesale market prices crashed between 8th November and 14 December. Finally, similar, every commodity, there was a steep fall in prices because there was no demand. And even the supply chain was disrupted. Moreover, even the logistics of demonetization have not been considered. This is the point I made earlier. I emphasize that. Over 2,300 crore notes were demonetized. Governments and RBI's printing presses in November 2016 could only print 300 crore notes per month. This gross mismatch meant it would take several months to even print the notes, making it impossible for all persons to exchange their notes within a reasonable time. Further, the government did not even consider the fact that over 215,000 ATMs would have to be recalibrated. In fact, in the initial days, the ATM did not take the 2,000 rupee note because it was not recalibrated. They did not consider that the 138,626 bank branches in India, over 2/3 were located in metro, urban, and semi-urban areas, with only 1/3 in rural areas. 90% of all ATMs were located merely in 16 states. Look at the next sentence. 7 states in the Northeast had only 5,199 ATMs, of which 3,645 were in Assam. So what about Arunachal, Mizoram, Meghalaya? This would mean that individuals living in rural areas and those in the Northeast would be disproportionately and adversely impacted. They would have to travel to other cities or towns to stand in lines to exchange notes. It is submitted that all these facts, this is my allegation, possible consequences were not duly researched or documented with RBI. nor were they placed before the central board, nor were they spelled out in the resolution recommendation of the central board, nor were they placed before the cabinet. Yet without knowledge of these facts, data and horrendous consequences, with the support of the cabinet decision, the executive government announced the impugned demonetization at 8 p.m. on 8/11. The consequence of not considering all the factors mentioned above was that demonetization cost the economy about 1 to 2% of the GDP, 150,000 crore. Further, as per data from the Center for Monitoring Indian Economy, millions of jobs were lost between January to April due to demonetization. Decision-making process was hopelessly and fatally flawed. Now I'll go on to the next proposition. The stated in the impugned notification dated 8/11 were false and illusory objectives that could not have been achieved, and in fact were not achieved for the impugned demonetization. The notification dated 8/11, your Lordship may kindly have that notification, which is at page in Mr. Jaideep Gupta's compilation, it was at page 13. It was at page 6 of Mr. Gupta's compilation. Please see the objectives. This is issued on 8/11 after the Honorable Prime Minister's announcement. Whereas the Central Board of Directors.
May I hand over a convenient compilation of all these in one place?
That's been given by RBI.
We have 200. Okay.
They've already, Lords have already got the RBI's.
Keep it.
Whereas the Central Board of Directors of the RBI has recommended that bank notes of denominations of the existing series, the value of 500 and 1,000, should be seized to be tenor.
Page 6.
In fact, you wrongly said page 6, it is page 4.
Page 3 and 4 in that compilation.
I'm reading from my compilation.
Yes, SO 3407E.
Yes, 340. The Lordship have seen it, but I want to show the objectives, which I skipped first time. Whereas it has been found that fake currency notes of the specified bank notes have been largely in circulation. So specified is 500 and 1,000. So they say fake currency of 500 and 1,000 have been largely in circulation. It has been found to be difficult to easily identify genuine banknotes from the fake ones, and the use of fake currency is causing adverse effect. That is point 1. Objective 2. It has been found that high denomination banknotes are used for storage of unaccounted wealth, as has been evident from the large cash recoveries made by law enforcement agents. That is black money. Then 3. Whereas it has also been found that the fake currency is being used for financing subversive activities such as drug trafficking and terrorism, causing damage to the economy and security. After due consideration, decided to implement recommendations of the board. So 3 objectives: fake currency note in 500 and 1,000, unaccounted wealth in 500 and 1,000 rupee notes, and third is that fake currency in 500 and 1,000 is used to finance terrorist activities. Now kindly look at the facts. I'm reading from page 16. It is submitted each one of these objectives was false. None of these objectives could have been achieved, that were in fact not achieved by the impugned demonetization. Regarding A and C, they are related, but fake currency. It is submitted that one of the purposes of demonetization is to draw people holding fake currency to exchange it for genuine currency, taking advantage of the exchange mechanism. When a fake currency note is detected by a bank officer, he is obliged to impound it and report the same to the RBI. RBI would destroy the note, thus taking the fake currency out of possible circulation. if the fake currency is not exchanged in a bank, this is the question which my Lord Justice Ramasubramanian put to me last time. It will remain in the hands of a fake currency holder and will be temporarily unusable as long as new currency notes of the same denomination are not issued. 500 and 1,000 will be immobilized as long as new 500 and 1,000 are not issued. However, it is universally accepted that the quantity or value of fake currency actually detected and impounded by the banking system, RBI, is a measure of the extent of fake currency. It is submitted. Annual report of the RBI for the year 2016-17 reported only fake currency of the value of 43 crore was detected in the nearly 15.31 lakh crore of currency exchanged. Out of 15.44 lakh crore, 15.31 lakh crore was exchanged. Out of that, they found 43 crore as fake currency. That fake currency represented 0.0028% of the total currency notes that were returned exchanged. So how does the objective of weeding out fake currency achieve? Because practically 15.44, 15.31 was exchanged. Good currency was given for the exchange currency. Some of them was fake, and you detected 0.0028. Now 0.0028 is 1 out of 10,000 notes is fake. That fake currency represented 0.0028. Hence the
But Mr. Chidambaram, we can also assume that the holders of fake currency may not have come forward.
That is only 15.44 lakh minus 15.31 lakh. 15.31 came back. Total 500 and 1,000, 15.44 lakh. Out of which 15.31 came back to that is the RBI report. So effectively only 0.13 lakh crore, that is 13,000 lakh crore remain. That is temporarily, assuming all of that is fake. No, I don't think assuming all of that is fake. I'll tell you, Lordship, why. Reports say, and contemporary reports, I don't think they can deny it, there is fake currency there is Indian currency in Nepal. Indian currency is perfectly legal tender in Nepal. Therefore, all that the Nepal Central Bank, Reserve Bank, and the Nepalis are in India, they go back, their families. The currency with them is not necessarily fake. That is part of the unreturned currency.
Okay.
Unreturned currency, one. Second, Indian embassies abroad, Indian consulates abroad have Indian currency. Maybe they were returned later, but if they were returned, it will be 15.31. But Indians abroad, millions of Indians abroad have Indian currency. They're entitled to keep Indian currency. Like an Indian can keep a certain amount of dollars and certain amount of pounds. An Indian abroad, NRI, OCI, they can also keep Indian currency. Like my learned friend. They would not have returned it. That is also part of this 13 lakh crore. Therefore, not necessarily all of that is fake currency. In fact, according to me, portion of that was fake currency. As my Lord said, they feared to exchange it. Therefore, they did not exchange.
This is what
I'm willing to accept that. I'm willing to concede that. But it can't be 100% of the unreturned currency was not fake. Because Nepal had Indian currency. And my Lord, Indian currencies by 2016, Indian currency is tradable in international exchange markets. Earlier, Indian currency was not tradable. Today, you can go to Singapore and ask for Indian currency. That exchange, the change counter will give you Indian currency if you want. You can surrender the Singapore dollars which are left with you and take Indian currency and come back to India. So Indian currency is in the hands of legitimate people And all that currency is not fake currency. All that is legitimate currency. Indians abroad, NRIs, OCIs, Indian embassies, consulates, Nepal. In fact, the biggest amount of, in fact, the Nepal Reserve Bank wrote back to our bank saying, we have so much currency, what do we do? And then they found a mechanism, etc., etc. The point is, bulk of the currency, 15.31 out of 15.44, that threw up 0.0028% of fake. Then fake currency notes that were not exchanged were presumably in the hands of fake currency holders. My Lord Justice Nazir said, we'll accept that as a possible event. They were temporarily immobilized because no fresh 500 and 1,000 rupee notes were issued to the government. However, soon after demonetization, new 500 denomination notes were issued by the government, and fake currency with a value of 500 and 2,000 again came into circulation. In fact, the Indian Express quoted a senior DRI official who said that while fake currency seized before demonetization was of low quality and easily identifiable with the naked eye, the quality of fake notes considerably improved post-demonetization, making it harder to spot. Thus, the so-called objective of detecting, impounding, and destroying fake currency notes hopelessly failed. One of the stated objectives was that fake currency had to be eliminated because it was financing subversive activities such as drug trafficking and terrorism. It is common knowledge that despite the impugned demonetization, drugs are being traded extensively. Like Punjab, it's being traded extensively. In fact, chief ministers have said it, ministers have said it, that Punjab is becoming a conduit for drug trafficking from the triangle. Nobody's case that by demonetization you eliminated drug trafficking. It is also common knowledge that terrorism is not abated. Only last week there was an international conference on terrorism, and the Honorable Home Minister said we must set up a NMFT, a separate agency to deal with financing of terrorism. NMFT, financing of terrorism. NM stands for new mechanism for to combat financing of terrorism. And then please read on, Miller. There is no evidence, there's only fake currency that was financing these subversive activities. New 2,000 rupee notes were found on the bodies of two terrorists killed in an encounter in Bandipora on 22nd November 2016. Hence, the stated objective also hopelessly failed. Well, terrorism can be financed by genuine currency as well as fake currency. By weeding out the fake currency by demonetizing, you're not stopping the financing of terrorism. Then the third objective was that, well, this, according to me, is the most amusing objectives in the light of what happened. The third objective was that people with unaccounted money were storing their unaccounted wealth in high denomination notes. Assuming this to be so, the Lordship recalls Dr. C.D. Deshmukh's statement, people don't store their black money, black wealth in currency notes stuffed in pillowcases and cupboards. The Lordship saw that statement. It is usually put in real property or gold or other things. Eliminating black money had not been returned to the banking system. In fact, the then learned Attorney General told this Honorable Court, bench presided over by the Honorable Chief Justice, Justice Thakur, that the government expected demonetized currency notes of the value, 3 crore is wrong, 3 lakh crore. Learned Attorney General said 3 lakh crore will not be returned, and that will be a windfall to the government. It was said in open court. It was reported in all the newspapers. However, according to the annual report of year 2017-18, Lord, I would request your Lordship to underline these numbers. Rupees 15,44,000 crore by value of demonetized notes. Rupees 15,31,000 crore by value were actually returned to the banking system. Thus, nearly 99.3% of the demonetized notes were returned, whether they represented storage of accounted wealth or unaccounted wealth. The inescapable conclusion is that practically all allegedly unaccounted wealth of black money stored in 500 and 1,000 rupee notes were exchanged, and the holder received valid currency notes, or what may be called white money. In fact, there has been commentaries which said that the demonetization exercise turned out to be a clever money laundering machine which allowed holders of unaccounted wealth to convert their wealth. So that if every note has been exchanged with new notes, what is the black money you detected by the system? 99.3 was exchanged. So you didn't detect any black money out of this exercise. Further, to facilitate this exchange of money, several brokers sprung up who offered to exchange demonetized note for a price. The Lordship again recalls Dr. Deshmukh's caution that all that will mean is people will start exchanging note for profit or loss. Broker will come in, and this is exactly what happened. Brokers came in and took your 100 rupee note, gave you 80 rupees, and he found a way to exchange the 500 rupee. He gave you 450 rupees. He found a way to exchange the 500 rupee note. And his profit is 50. Then immediately after, this is the most amusing part which I've never understood. Immediately after demonetization, government introduced for the first time 2,000 rupee notes. If the objective was to eliminate unaccounted wealth black money stored in 500 and 1,000, there was little sense in introducing 2,000 rupee notes. What would require 4 notes of rupees 500 or 2 notes of rupees 1,000 could be easily stored and more conveniently in 1 note of 2,000. Thus, the introduction of 2,000 rupee notes immediately after demonetization actually facilitated holders of black money. That black money was in fact stored in 2,000 rupee notes was proved shortly when the Income Tax Department and the Directorate of Revenue Intelligence in their searches and raids shortly after demonetization seized alleged unaccounted wealth in the form of 2,000 rupee notes. Thus, instead of eliminating unaccounted wealth, black money, demonetization, and the introduction of 2,000 rupee notes actually facilitated storing unaccounted wealth in high value. But realizing it later, they've discontinued the 2,000 rupee notes. The Lordship remembers that famous episode where Mr. Ram Jethmalani tried to prove that 1 crore can be stuffed into a suitcase. Lordship may have. Now, the highest note was 1,000. Now today, with 2,000 rupee notes, he can store it in half a suitcase. What is this? What is this logic of 2,000 rupee notes when you're demonetizing 500,000?
Now I am occupying that house, but I did not find one.
Thus, every one of and bribery, as bribes could always be taken in new notes. Well, again, I'm quoting an example. A case of bribery was reported from Gujarat, where officials of the Kandla Port Trust were caught receiving 124 notes of rupees 2,000. So you can bribe a person in 2,000 rupee notes. How is corruption, how is black money, and how is counterfeit? Those objectives are achieved by demonetization. Nobody's even, there's huge criticism of these 3 objectives. The only relevant objective of demonetization is what I said, namely unusable or unused currency and hyperinflation. These are all false objectives. In fact, the data will show they were not achieved. The Central Board of the RBI had a duty to caution the government, following, if I may add, Dr. Deshmukh and Dr. Patel, that the 3 objectives could not be achieved by demonetization. Since after receiving the recommendation of the RBI in the impugned notification dated 8/11, the 3 objectives were reiterated. The only conclusion that can be arrived at is that the government had set false objectives in order to justify its arbitrary and illegal action. The next proposition, Murad, is 6th. This is important, but and I rely upon case law, I'll speak to that. Applying the test of proportionality, the alleged recommendation of the RBI and the impugned decision of the government deserve to be struck down on the ground. The demonetization, in the manner it was done, imposed a disproportionate and intolerable burden upon the people, resulting in loss of hundreds of lives and loss of livelihood for millions of citizens. This honorable court has in a catena of decisions held that every decision of the government must be tested on the doctrine of proportionality. It is submitted that the doctrine of proportionality would apply even to decisions presented as economic decisions. It is submitted that judicial review extends to reviewing economic decisions by applying the well-known test of judicial review, including the test of proportionality. Applying the test of proportionality to the impugned demonetization. It is submitted.
What can be done now? It is over now. First point we appreciate. Of course, 26-2, you want to say it won't come under 26-2.
Yes.
That is your legal argument. We will consider that.
Yes.
All the other points are all relating to past events, which is over now.
Correct, but the law.
That's why you remember at the threshold, we said whether the writ petition survive.
Lordships have said, and I'll justify that submission. You will state the law. Please state the law. What is 26.2? What is the limit of its power? And what are the matters that should be taken into account? If your lordships hold that this decision, this process was flawed, material was not considered, that itself is good enough so that they will not embark upon such a misadventure in future. Lordship, I'll cite case law for that. The lordships have held that you can declare the law, even if no immediate relief can be granted to all the petitioners. But in the case of Mr. Diwan, if your lordships accept our argument, your lordships will consider giving relief to him. And the other gentleman who had 30,000 rupees, relief to him. He should be given relief. Why should he be denied relief? 99.
We were discussing about 30,000 because we heard that argument several times about 30,000. We said 6,000 each we will contribute and
99.3% of the notes were exchanged.
or attorney will may offer. He stood up.
My learned friend can offer more.
Why should you deny it to the people with 30,000? What was your 1 lakh? 1,61,000. Why should he be denied?
Then you will have.
99.3 has come back.
No, only thing what we were actually looking at was, maybe your argument to say that 26(2) not followed
Yes.
the procedure that was required to
Yeah.
be followed. On that, we'll have to state whether that has been followed or not. Now, supposing that procedure was followed, I mean, at least that was my thing. Supposing we accept that that procedure was followed and it was done for the same reason and the object was not achieved. So object wise, what we feel is that may not be very relevant. But whether they followed 26(2), as you rightly say, to come to a conclusion, and if it is wrong, to lay down for the future
Yes.
to say that it had to be followed.
But I'll be
That may be
satisfied with
right.
that.
But for saying that these were the objectives and that has not been achieved may not be much relevance is what.
Well, it may not be relevant. Why I'm say putting forward these objectives is
To say the
this is what
urgency,
the
that was,
notification said.
to say the urgency, this was not the reason.
These are the objectives, then what did you consider?
Correct. So what you say is 26(2) still for consideration? Yes, that's.
Firstly, whether 26(2) is limited, as I'm arguing, or is unlimited power. And assuming whatever the power in 26(2) was the process power, the decision-making process.
Correct. So
was
that
it
maybe to concentrate more on that would be better instead of saying
But
the,
I'm just
it
one more
failed.
page, man.
Instead
One
of
more
saying it
page.
failed.
I'm just
Even if it
done.
failed, the procedure should have been followed is what you.
I've just completed, Miller. It's only one more page.
All right, all.
But even if the procedure had been followed, this impact or adverse effect could have also happened.
Not necessarily, Miller. If the decision-making process had been what it ought to be, and if they had taken into account all this data and material, they may not have, I'm saying, may not have withdrawn the 500 rupee note.
So what you're saying, the expert advice which they would have received would have made them change. their
Like
mind.
Dr. Patel and Dr. Deshmukh said, this is not, why has there been no demonetization in any country that I know of in the last? Only with this hyperinflation they've demonetized. There's
What we're
never
trying
been a
to say-
demonetization.
See, the effect or the impact of a governmental action
Yes.
cannot have any real bearing on its validity.
No, man. Applying the test of proportionality, your lordship can say this was an unreasonable action. Your lordship may not be able to undo the effect of that action, but your lordships can say on applying the test of proportionality, this was an unreasonable action. In fact, my Lord Justice Ramasubramanian's judgment says exactly that. I'm strongly relying upon that judgment. Cryptocurrency, same government, same RBI. The court held, applying the test of proportionality, we don't accept this. Therefore, my Lord, I will be satisfied if your lordships agree with me, if your lordships are pleased to agree with me, that 26(2) is a limited power. If you want to demonetize all the series, you must have separate legislation. Number two, assuming under 26(2) you have the power, the decision-making process must be well documented, followed strictly in letter and spirit. You can't have such a opaque, hurried, rushed, reversed process. This is a reverse process. This is standing on its head. Those are the two main submissions, proposition 1 and 2. I am satisfied, but other petitioners obviously will ask for relief. If your lordships accept that, then your lordships will have to consider here then whether they deserve relief even after 6 years. They've been waiting for 6 years to get some relief. They may get relief. Let me complete it, Miller. It'll take only 5 minutes. Middle of page 21. There was absolutely no justification to demonetize 86.4%. Caused enormous damage to the economy, placed an intolerable and horrendous burden. There were other means. This is important because this is one of the considerations which my lords have said, and that is also in that cryptocurrency judgment. You must consider whether there are other means to achieve the same objective, which ought to have been explored to achieve the objective of seizing and destroying fake currency and detecting unaccounted money, black money. It is obvious that no such alternative methods or schemes were examined either by the RBI or the central government. If any such alternative methods or schemes were examined by the RBI or the central government, respondents 1 and 2 are obliged to place before this court evidence that such an examination is undertaken, and after examination of all the alternatives, the RBI and the central government came to the conclusion that demonetizing 500 and 1,000 was the best method of achieving objectives. In the absence of such evidence, it is submitted, applying the test of proportionality. This honorable court should declare that the impugned demonetization failed the test of proportionality. Then, my lord, the last proposition. Despite the passage of time, this honorable court has the power to grant relief, including declaring the true meaning and interpretation of various provisions of the RBI Act. This honorable court has also the power to mold the reliefs. It is submitted in the following cases of this honorable court. It was held, despite the passage of time since the impugned decision, this honorable court can issue a writ of declaration in suitable cases. This power is available under 32, 141 and 142. And the two judgments, I won't cite them, I'll just read them here. One is Somaya Organics, 2001 5 SEC. And these are the two paragraphs. In the ultimate analysis, prospective overruling, despite the terminology, is only a recognition of the principle that the court molds the reliefs claimed to meet the justice of the case. Justice not in its logical, but in its equitable sense. As far as this country is concerned, the power has been expressly conferred by Article 142 and Para 37. Nevertheless, a law enacted without legislative competence remains in the statute book till a court of competent jurisdiction adjudicates thereon and declares it to be void. When the court declares it to be void, it is only then it can be said that it is non-est for all purposes. In synthetics chemicals, the invalidity of the provisions was a declaration under 141. It was for doing complete justice of the court in exercise of the jurisdiction of Article 142, molded the relief in such a way as to give its declaration prospectively. It is not possible to accept that such an order of prospective overruling is contrary to law. An invalid law has not been held to be valid. All that has happened is that the declaration of invalidity was directed to take effect from the future. If your lordships hold that the impugned demonetization of 811 was illegal, that will give content to my argument on round 1 and 2. And it will be a caution to the government in future, you can't do this. In future, you can't use this power because this power is not available to you. And 2, even if this power is available to you, you have to follow a fair and transparent procedure to reach that decision. In Odisha Cement held by this court, the declaration regarding the invalidity of a provision and the determination of the relief that should be granted in consequence thereof are two different things. And the latter sphere, the court has and must be held to have a certain amount of discretion. This well-settled proposition open to the court of grant. In Golaknath, it is a modern doctrine suitable for a fast-moving society. It does not do away with the doctrine of stare decisis, but confines it to fast transactions. It is true that in one sense, the court only declares the law, either customary or statutory or personal. While in strict theory, it may be said that the doctrine involves making a law. What the court really does is to declare the law, but refuses to give retroactivity. It is really a pragmatic solution, reconciling the two conflicting doctrines, namely, the court finds law and that it does make law. It finds law, but restricts its operation to the future. It enables the court to bring about a smooth transition by correcting its errors without disturbing the impact of those errors on the past transaction. It is left to the discretion of the court to prescribe the limits of retroactivity. Well, those are my propositions. And I'll wind up now with just some case law. Now, my lords, I've shown your lordship the government counter, page 31 to 34, of the counter of 2018, reiterated in the short counter of 2022. It candidly admits that the recommendation came from the government. It uses words like recommendation of the government, advice of government, proposal of government. It uses those three words. So it's absolutely clear that it emanated from the government to the RBI, and the RBI merely responded, in my view, meekly responded. Whatever they proposed, they accepted, and they said yes. Now, RBI has filed a counter. Doesn't take us very far, but I'm obliged to draw the attention of the Honorable Court to what the RBI has to say. There's an RBI counter. There are two affidavits that has been taken out. 2018 affidavit, sworn to by one Oaklal Cookie.
But here as well, my lord, we have prepared a compilation of all the affidavits filed by RBI in this matter. There are 4 such. In 4 matters, my lord, counters have been filed. So that all the counters are, my lord, collected in one compilation.
It's page 41.
Including the last one.
Sworn to by one Oaklal, son of
Yes.
Cookie.
Is it page 37 in this compilation?
Yes, yes.
No, my lord. Yeah, if my learned friend is looking at the last one, the first one,
37.
yes, page 37.
I just want to show, your lordship may keep that for me.
Yes.
Now kindly see paragraph 4.
Yes, paragraph 4.
This is the opening paragraph. The Deputy Governor's memorandum recommending withdrawal of legal tender status of banknotes 500,000, along with a copy of the letter number so-and-so dated 7th November. Fortunately, Miller, the number has been disclosed here. The 7th November letter received from the Ministry of Finance, Government of India, and draft scheme for implementing the withdrawal was considered in the 561st meeting of the Central Board, which was held on 8/11, confirms at 5:30 p.m. So the meeting took place at 5:30. It was lasted an hour. Now, apart from this, there's nothing disclosed about what the contents of the letter was and what the contents of the recommendation is. The rest is all, my lord. Kindly see the language. But the board discussed various relevant aspects of the matter. That the board was assured that matter has been discussed. I can't understand. How can the board be assured that matter has been discussed between central government and Reserve Bank? Who assured whom? The board was assured that matter has been discussed between central government and Reserve Bank and have been under discussion over the last 6 months. This is not stated in the Government of India's affidavit. The proposed step presents a big opportunity to take the process of financial inclusion and incentivizing use of electronic modes of payment. These are very different objectives. These are not mentioned in the notification. Financial inclusion and incentivizing is nowhere in the notification. This is a very different objective, digitization. There are 2 comments on paragraph 2. Government's affidavit does not say of any discussion over the last 6 months. Second, financial inclusion and incentivizing is not the objective of the notification. Then, the board was assured that the government will take mitigating measure to contain the use of cash. Again, my lord, not an objective of the 811 notification. Objective of the 811 notification is only three: weeding out fake currency, unearthing black money, stopping fake currency financing terrorism. Nothing about using less cash. Then the board considered the memorandum and after detailed deliberations concluded in larger public interest, the balance of advantage would lie in withdrawal of legal tender of 500,000. Accordingly, it was resolved by the central board for recommendation of the withdrawal of legal tender of the old bank notes. I don't understand. Old bank notes. Where do you get old bank notes? All bank notes are 500,000. Did they have in mind only old bank notes, old series? All bank notes were being demonetized. And the affidavit says withdrawal of legal tender of the old bank notes. What is old, Miller? It shows complete non-application of mind in filing this affidavit. Kindly see, Miller. My comments are rather severe comments. One, there's no disclosure of any discussion in the Union of India's affidavit. This financial inclusion and incentivizing use of electronic modes is not an objective of 811. Less cash is not the objective of 811. And they say we are recommending withdrawing of legal tender of the old bank notes. They were under the impression only old bank notes will be over the 5:30 they meet. 8 o'clock is the Honorable Prime Minister's announcement. So you have 2.5 hours. In 2.5 hours, all these momentous events took place. Agenda note placed, discussion, detailed deliberations, then recording it, typing it, or transmitting it to the cabinet, cabinet note being prepared, cabinet considering and announcing. What kind of a decision-making process is this? This is the most outrageous decision-making process which makes a mockery of the rule of law in this country. This decision-making process must be struck down by your lordships as saying this is a flawed, deeply flawed decision-making process. Then, my lord, kindly come to paragraph 21. Paragraph 21 is a long paragraph. Now, 21, over the page. It is further submitted that section 26 provides for legal tender. 26(1), every bank note should be legal tender. Central government to declare that any series of bank notes of any denomination shall cease to be legal tender. The procedure for conducting the business of central board has been provided under the Reserve Bank of India regulation, which I showed to your lordship. Central board is regulation 8. Committee, we are not concerned with committee, regulation 10. In compliance with the provisions of section 26, read with regulation 8, the meeting of the central board and the committee of the central board. Well, a committee of central board is subsumed in the central board. But the answering respondent was held on 8th November at New Delhi and a resolution was made. After the resolution was passed, the same was communicated to the central government on 8/11. Thereafter, the central government by notification dated 8/11. All this happened in 2.5 hours. And they don't disclose who was present, who was absent, whether a quorum was there, what is the terms of the resolution, nothing is disclosed. The rest of this affidavit, I'm not reading a lot, is all that about the measures they took to mitigate the hardship on people. The second affidavit is filed one Mr. H.S. Parihar.
This is just now 2024.
I'm sorry. No.
What is about 2020? Yes.
Kuntal came.
Page one. Page one. That's page one. Kuntal came. Kuntal came.
One of them.
So kindly come to paragraph 21, Lord.
Oh, yes.
That on 12/10/22, when this honorable court heard the subject matter and the intervention applications, learned senior counsel appearing on behalf of the petitioner Adil Alvi, my client, placed certain broad heads on which arguments were proposed to be advanced on behalf of the said petitioner. The said submissions have been followed up by the detailed additional affidavit dated 4/11. Alert, it was served on 5/11 and filed here on 7/11, the affidavit which I read. So they are aware of that affidavit. They acknowledge that affidavit, but don't deal with the facts mentioned and the data mentioned there. Now kindly come, my lord, to page 21. This is 23C, subparagraph C of paragraph 23. Page 21. Whether the decision-making process was flawed. It is reiterated that in compliance with the provisions of section 26, read with etc., meeting of the central board was held in New Delhi on 8th November. After detailed deliberation, board concluded larger public interest would lie withdrawing legal tender status of 500 and 1,000. The word old is missing here. Old was there in the original affidavit. Old is missing here. Currency notes in circulation and pass the resolution. After the resolution was passed, the same was communicated to the central government on 8th November. Therefore, it is not correct to say, to contend that roles of RBI were reversed. But roles of RBI were reversed is apparent from the Union of India's affidavit. Kindly come to D, Miller. It is reiterated that the board had discussed and considered various relevant aspects of the matter before passing the resolution on 8/11, recommending the withdrawal of legal tender of SPNs. These aspects include inter alia, counterfeit currency, black money. The next is not there, incentivizing the use of electronic mode, financial inclusion, etc., etc. On page 29, H, letter of government dated 7/11, agenda note of 8/11 and recommendation 8/11, not in public domain. The mere fact that the aforesaid documents are not in public domain does not entitle the petitioner to seek any relief when the impugned notification issued by the government on cessation of legal tender notes clearly in its recitals, reveals a recommendation made by the Reserve Bank and also contains the objective of which the legal tender character is being withdrawn, as well as due consideration by the central government while deciding to implement the recommendation. notification clearly records the findings being fake currency, high denomination for black money and fake currency. That's all. The documents. What these are? How do these affidavits advance our case? Let them show the documents, 711, 811, 2, 3 documents, and finally the cabinet decision. But I'll conclude with just by indicating the case law. The first 2 decisions are that that is a second proposition. If my first submission is kept aside, the second submission is 26(2) confers an unguided, uncanalized power. There are 2 judgments. AR 1960, Supreme Court 554. They were the books. That's all. So. This is 1960, volume 2, SCR 671. AR 60, Supreme Court 554. A Constitution bench, Miller. Well, I'm only reading few sentences which are relevant. Paragraph 31 contains the impugned provision of law. Paragraph 31. The power given to the authority, paragraph 31. The power given to the authority under that provision is contained in clause D. Subject to the provisions of this act, no person shall take any part in the publication of any advertisement referring to any drug in terms which suggest or are calculated to lead to the use of that drug for the diagnosis, cure, mitigation, treatment, or prevention of any venereal disease or any other disease or condition which may be specified in rules made under this act. The proposition of law is just above Miller. Kindly see paragraph 28.
You are reading from SCR, I think.
I'm reading from SCC.
Not the morning compilation that we are given.
I think AR, what you read is in para 32.
Paragraphs are
32 in AR.
32. I think.
Morning compilation, it's the last, it's annexed as the last.
Last judgment, yes. Hamdard Dawakana is enclosed, correct.
Now we are at, you tell us paragraph, we can.
Because for the petitioner, it was argued.
well, I'm reading.
How does it begin?
You must see the broadly.
Paragraph which I have read is paragraph 31, the power given to the.
That is in 32. 32.
Now I'm reading paragraph 28, which starts the third point raised.
Para
by
29. Para 29.
Now kindly come towards the end of the paragraph. The proper distinction there pointed out was this. Lordship gets the quotation. There's one quotation to put it to the language of another amendment.
Yes.
And the
yes.
second quotation.
Yes. Yes, we have.
No, I'm having both. So that we can adjust to.
Very well.
All right.
The proper distinction there pointed out was this. The legislature cannot delegate its power to make a law, but it can make a law to delegate a power to determine some fact or state of things upon which the law makes or intends to make its own action depend. There are many things upon which wise and useful legislation must depend, which cannot be known to the law-making power and must therefore be subject of inquiry and determination outside the hall of legislatures. But the discretion should not be so wide that it is impossible to discern its limits. There must instead be definite boundaries within which the powers of the administrative authority are exercisable. Delegation should not be so indefinite as to amount to an abdication of the legislative function. Now, my lord, the conclusion about this case starts in the paragraph reading 4 paragraphs below. The interdiction under the Act.
Yes, 34.
34. The interdiction under the Act is applicable to conditions and diseases set out in the various clauses, and to those that may, under the last part of Clause D, be specified in the rules. The first subsection of Section 16 authorizes the making of rules, etc. It is the first subsection of Section 16 which confers the general method. It delegates to the administrative authority the power to frame rules and regulations to subserve the object and purpose of the Act. Clause A of the second subsection is merely illustrative of the power given under the first exception, that is Sibna. Therefore, under subsection 2A also has the same object as subsection 1 to carry out the purposes of the Act. Consequently, when the rule-making authority specifies conditions and diseases in the schedule, it exercises the same delegated authority as it done when it exercises powers under subsection 1 and makes other rules, and therefore it is delegated legislation. The question for decision then is the delegation constitutional in that the administrative authority has been supplied with proper guidance? In our view, the words impugned are vague. Parliament has established no criteria, no standards, and has not prescribed any principle on which a particular disease or condition is to be specified in the schedule. It is not stated what facts or circumstances are to be taken into consideration to include a particular condition or disease. The power of specifying diseases and conditions as given in Section 3D must therefore be held to go beyond permissible boundaries of valid delegation. As a consequence, the schedule in the rules must be struck down, but that would not affect such conditions and diseases which properly fall within the 4 clauses of Section 3, excluding the portion of Clause D, which has been declared to be unconstitutional. In the view we have taken, it is unnecessary to consider the applicability of Baxter versus Way. We are of the opinion, therefore, that the words or any other disease or condition which may be specified in the rules made under this Act confer uncanalized and uncontrolled power to the executive and are therefore ultra vires, or they are being taken out, etc. Will not compare now 26(2). Any series, even a series of notes issued the previous day, that of course is an extreme example, but the extreme example illustrates the flaw in the way the section is worded. Therefore, I would urge your lordship to accept proposition 1, which would become a limitation on section 26(2), that any series means only any specified series. If you apply to all series, then there is no guidance at all. So the second case, second and the last case on this point is 1969 QSCC 166. 19. Section 4 of the Act empowers the administrator to authorize such person as he thinks fit to also exercise all or any powers exercised by him under the Act, with certain exceptions. And different persons may be authorized to exercise different powers. Section 4(5) states, any person authorized by the administrator to exercise any powers may exercise those powers in the same manner and with the same effect as if they had been conferred on that person directly by this Act and not by way of authorization. After having heard the argument of Mr. Daftari, we are not satisfied with the delegation of power conferred by Section 4(4) and 4(5) goes beyond the permissible constitutional limits. Delegation with the administrator is necessary for the volume of work entrusted to him. Absence of such power might seriously impair administrative efficiency. Section 4(4) contemplates that the administrator may authorize such person as he thinks fit, etc. It must be assumed that the administrator will delegate his authority only to competent and responsible persons. It was then said to the provision that part is upheld. It was then said to the provisions of Section 5(1) conferred wide and uncontrolled power without any guidelines and was capable of being used with arbitrary discrimination. But Section 5(1) requires that the administrator should have regard to the policy of the Act in making his orders. His orders should be made within the framework of the Act and should not be inconsistent with the provisions of the Act. As regards 5(2)(a), the argument was that unguided power is conferred upon the administrator as delegate to regulate or fix the price at which any gold, whether it's primary gold, article, or ornament, should be sold. As a power to fix the price may also be exercised not only in respect of primary gold, but also in respect of articles and ornaments, the business of the petitioners and similarly will be adversely affected. But the section provides the safeguard that the regulation of the price should be made by the administrator after consultation with the Reserve Bank of India. It is argued that the phrase, so far as it appears to him to be necessary or expedient for carrying out the provisions of the Act, was a subjective formula and action of the administrator in making the orders under 5(2) may be arbitrary and unreasonable. But in our opinion, the formula is not subjective and does not constitute the administrator the sole judge. On the contrary, we hold in the context of the scheme and object of the legislature as a whole, the expression cannot be construed as objective. But all this has been upheld. Then kindly come to 20. So they discuss each provision and say, no, this is permissible, this is canalized, this is guided. Now kindly come to paragraph